Yes.
Matter may kindly be listed for orders next week, my lord. It was directed to be listed in the month of September, my lord.
Month of
September it was directed to be listed, but not listed, my lord. And it will be listed on next week, my lord. Immediate, my lord, next week.
Okay. Kobe?
28. 28.
Lordship, I beg to mention one listing for IA, Lordship. The second appeal already been admitted by this honorable court, Lordship. IA for stay, Lordship, on tomorrow or day after tomorrow, Lordship.
Tomorrow is hearing day.
Day after tomorrow,
Okay, possible.
Yes, on 23rd.
Okay.
of light, Lordship.
May I please, Your Lordship? I beg to mention an item for listing CRP-IO for orders. Can it be taken up day after tomorrow?
Kobe?
Day after tomorrow. Okay. Wonderful.
Obliged.
May it please your lordship. First, I beg to mention one RS award pending matter for hearing in the month of November, lordship.
November?
2012 matter, lordship.
Okay.
Master. Please, lordship. Therefore, listing a CRPI, lordship. In this matter, lordship, the respondent side, the petitioner side challenge a ex parte order, lordship. Thereafter, we get the status quo order. But by violating that order, they have started some construction. So this matter may be list on next Tuesday, lord.
Next Tuesday means tomorrow?
Tomorrow.
Tomorrow hearing day.
Lordship, then Thursday, lordship.
Okay.
May it please your lordship, I beg to mention one appeal. It's a 2013 appeal. Lordship, according to the previous order, the matter was supposed to be listed after 1 week due to lack of filing of the wakalatnama. Lordship may kindly let the matter be listed for hearing.
On
Kobe?
7th November.
Much obliged.
Sir, I beg to mention for item number 8 and 9, CLP-IO, my lord. Yeah, our looking at what AK Purka, so here's some problem today. So only for today, my lord. Maybe come after that the tomorrow, my lord.
On the appearing made by Mr.
MJ Burwa, my lord.
M.J. Borwa, learned counsel for the petitioner. Recessal is the matter on
Day after tomorrow, my lord, before.
day after tomorrow.
Yes, my lord.
Okay.
He
Okay.
instructed me like that.
Okay.
Obliged, sir. May I please, lordship? I beg to mention for listing BA, lordship, under rejected by your
BA.
BA, lordship. The lordship has rejected earlier, lordship.
Maybe, but we are not taking up the bail matters. You mentioned the other senior court who has been taking up the criminal matters.
14.
Also, it mentioned senior court.
Mention before the senior court, that letter will come accordingly.
May I have your lordship?
Yes.
This is private matter.
Yes.
Before vacation, it was listed for hearing, but Mr. as the senior counsel took that, so it may kindly be listed on Thursday.
Okay.
May it please your lordship. My lord, with respect to item number 30, my lord, before your lordship. My lord, in this case, the matter to be listed for admission, my lord.
30.
30, my lord. Service on all respondents has been clear, as per the office note, my lord. But they may be taken on the day after tomorrow.
We'll call the matter.
My lord,
We'll call the matter. We'll call the matter.
May it please your lordship. I
Yes.
beg to mention for listing of a CRP-IO matter for Wednesday, your lordship.
Wednesday.
Yes, your lordship.
Okay.
Highly obliged.
Okay.
Items from daily list for motion, item number 1.
may I please be below. Lordship, this is a for notice some deliberation and dismissal, lordship, and a similar order has been passed by your lordship
Mm.
in MSc April, lordship.
Mm. Whether any police case has been registered or not?
Yes, yes, lordship. This is-
What is the number?
Yes. We mentioned in the police case in the Kansari PS case number 366. Please.
Heard Mr. A.R. Agarwal, learned counsel for the petitioner. Order dated 2/7/2024 passed by the learned member MSCT Amin Gao Kamrup. in MSc. Case number 34 of 2023 is challenge in this petition under Article 227 of the Constitution of India. Read with section 15 of the Code of Civil Procedure. It is to be noted here that by the impugn order dated 2/7/2024, the learned member MSCT Amingo Kamru has dismissed the claim petition filed by the petitioner on the ground that Limitation Act is not applicable in case of MB Act 2019, as the MB Act by itself has set a period of limitation and it cannot be overridden by the Limitation Act. Mr. Agarwal, learned counsel for the petitioner, submits that the petitioner has instituted the claim petition before the learned member MSCT Amingo Kamrup. Claiming compensation on account of death of Khonin Saloy alias Khonindra Chandra Saloy in a motor accident that took place on 3/9/2022 at Sangsari under Sangsari Police Station. Mr. Agarwal further submits that while the accident took place on 3/9/2022, the claim petition was filed before the learned member on when it was filed before the court 10/4/2023, and in filing the said claim petition there was delay of 39 days. And the petitioner, along with the claim petition, has filed another petition for condonation of delay of 39 days in filing the claim petition. But the learned tribunal, by order dated 2/7/2024, dismissed the same on the ground that Section 166(3) MB Act 2019 specifically provides that no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. I would like to click on.
I think that the learned member of 10/4 the same claim petition there will be of petition along with the claim petition and file another petition for conversion of delay of 39 days in filing the claim petition. So, but the learned tribunal filed order 2/7/24 dismissed the same on the ground of section 166(3) of the NBA.
And As the Limitation Act is not applicable in cases under MV Act 2019, the MV Act by itself has set a period of limitation and it cannot be overridden by the Limitation Act. Mr. Agarwal further submits that what is the ground for delay?
Count for delay is that when the remedy filing the time limit, they don't know to limit.
In which paragraph of your petition you have explained it?
That is mentioned in the paragraph 2, that sitting continuance of delay. So 37 days only, 39 days only, that is mentioned. Financial hardship in the order it is mentioned also.
Mr. Agarwal, learned counsel for the petitioner submits that on account of financial hardships, the petitioners could not approach the learned member MSCT, Amingao Kamrok, within the stipulated period of 6 months. And therefore, Mr. Agarwal has contended to set aside the impugn order and to remand the matter back to the learned tribunal to proceed with the same in accordance with law. But having heard the submission of Mr. Agarwal, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on the record and also perused the impugn order dated so and so. But it appears that the occurrence, that the accident took place on 3/9/2022 at Sangsari under Sangsari PS, and in connection with the same, one FIR was also lodged upon which the Sangsari PS, the officer inserts Sangsari PS has registered a case being Sangsari PS case number 366 of 2022 under section 279/304 AIPC. It is to be noted here that in the case of Gohar Mohammed versus Uttar Pradesh State Road Transport Corporation and another in SLP, which will make it C, number 32448 of 2018. Honorable Supreme Court has held that while registering a case, police has to forward a copy of the accident information report to the jurisdictional motor accident claim tribunal, and on receipt of the same, the learned member of the tribunal shall treat the same as claim petition and proceed with the same. In view of the aforesaid decision of Honorable Supreme Court, this court is inclined to set aside the impugn order dated so and so and to remand the matter back to the learned tribunal to inquire as to whether any accident report was prepared by the officer in search, Sangsari PS, and the same was forwarded to the claim tribunal, and if so, the same shall be treated as claim petition. And thereafter proceed to hear and dispose of the matter in accordance with law in terms of above this. CRP instance and dispose of at this motion is as it such.
Lordship, with similar matter is there in item number 33, Lordship, but in that item, there is delay on my part. There is a delay in filing this. CRP. So it can be disposed of by the party.
What is the limitation period?
Limited is 6 months. And limited period here is 90 days, 3 months. Earlier there was not there, but in the back to 90 days. So,
In preferring revision?
yes. But actually that should have been, the CRP in the 90 days it has been made. But there is further delay of 47 days.
No, this 90 days delay is prescribed in where? In which act?
Here CPC, if it is not there, but in the rest, they have maintained the charge that it is given there, 90 days.
Raise the-
CPC, yes, Lordship. CPC, I have not found it.
So you can issue notice. Will issue notice. I heard Mr. A.R. Agarwala, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant Ilyas Ahmed for condonation of delay of 47 days in preferring CRP number in preferring SCRP against the order dated 9/4/2024 passed by the learned member MSCT Barpeta in MSC case number 37 of 2024. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process with any referring to them. List the matter after 4 weeks.
Item number 2.
Here in this CRP Lordship, we have challenged the order of this MSC tribunal, Margarita Lordship. 10th order. What happened, Lordship, in this case, award was passed, and accordingly, Lordship, we have deposited 24,29,004 rupees, Lordship. Out of the total calculation of 21,855. Because, Lordship, the claimant could not provide the PAN card, and the PAN card was not accessible in our system. And as per the provision of Income Tax Act, Lordship, we have to deduct 20% of the TDS.
Who is provision?
Yes, Lordship. I have the provision, Lordship. It's 206AA of the Income Tax Act. We have to follow the procedures, the statutory provision, Lordship. We have to follow. In case the claimant provides the PAN card, we have to deduct 10%. And in case it is not provided, as per this provision, Lordship, we have to deduct 20%. This is the situation, Lordship. That's why we had deducted 20% of the total awarded amount. And that was not accepted by the Land Tribunal, Lordship. The claimant had filed a execution petition, Lordship. In that execution petition, Lordship, we have filed a petition stating all these facts, Lordship. That same was rejected, Lordship, on the ground that we have no locus standi.
No, whether the law is settled.
Yes,
that,
law is settled, Lordship. We have some decisions also. Law is.
Who is this? Sir?
Yeah, Lordship. I'm providing, Lordship. I'm relying on one Supreme Court decision, Lordship, and one Madhya Pradesh High Court decision, Lordship. In Supreme Court decision, Lordship, in a similar issues, Lordship, what happened? The claimant approached the High Court, and the High Court directed the claimant to approach the Income Tax Department for the deduction of the TDS amount. And later on, this writ petition was filed in the Supreme Court Lordship. That was dismissed by the Honorable Supreme Court Lordship, stating that there is no locus standi on the on behalf of the petitioner, and the same was dismissed. This issue has been settled already, and there is another judgment of Madhya Pradesh High Court.
No, in Supreme Court, which judgment it has been settled?
Lordship, Supreme Court Lordship, there was an Omit Sahini who filed a writ petition, Lordship, challenging this reduction of the TDS amount. First of all, he has approached the High Court. Thereafter, High Court directed him to approach the Income Tax Authority, Lordship, and the Income Tax Authority also rejected this plea, Lordship. Thereafter, he approached the Honorable Supreme Court. And Supreme Court says that he has no locus standi in this matter. No, there is no prima facie case in this matter. This same is rejected. Again, Madhya Pradesh High Court has cleared this position, Lordship. Madhya Pradesh High Court decision is clear, Lordship. There is another other judgments also, but I am referring this Madhya Pradesh High Court, Lordship. The second one, Lordship. The head notes, Lordship. The head notes, first of all,
No head note. You produce the entire judgment.
This entire judgment is here. Lordship may peruse pair number 9 and 12 of that Madhya Pradesh High Court. Pair number 9 and 12 other 11 parts, Lordship, where it has been cleared. Lordship, in pair number 9, it is stated that in the matter of National Insurance Company Limited versus Protiva, share number so and so, share so and so. After placing reliance on a decision in the matter of Vitapen Thermas 5 Sah 2004, this court has held that since amount of interest was more than 50,000, therefore, the insurance company was bound to deduct TDS. Lordship, again, Lordship, in pair number 12, this provision has been explained. That is 194A of the Income Tax Act. Under this provision, Lordship, we have to deduct the TDS. In pair number 12, Lordship, I am reading the relevant part in the middle of the paras. Thus, if the amount of interest to the claimant in particular financial year does not exceed 50,000, then person is responsible for payment is not required to deduct tax at source. Since the deduction is to be made at the time of payment.
Which judgment you were reading?
Madhya Pradesh High Court, Lordship. Madhya Pradesh High Court, Lordship, pair number 12. I am also providing with the Lordship relevant section, that is 194A. As per this provision, Lordship, if the interest amount is more than 50,000, we have to deduct the TDS. And it is not an issue that he cannot claim in that TDS amount for refund. He can approach the income tax department for refund of the amount also. And in this judgment also, Lordship, I think somewhere it has been discussed. And as for this section Lordship 206 AA, we had to deduct 20% of the TDS because the PAN card that was provided by the claimant was not accessible in the system. As, when we make the payment, Lordship,
Who is responsible for the same?
Lordship,
Who is responsible for the same?
the claimant side.
His PAN card is not accessible in your system. Who is responsible for the same?
So the claimant that we have contacted, but that number was not accessible. I think that was not correct number. So we have already deposited the amount. We are ready to deposit another 10% if the claimant is able to furnish the latest PAN card number. We are ready, Lordship. When nothing that we have arbitrarily deducted, we have to follow some procedure. And this procedure is followed by.
How you have ascertained that the PAN number is not correct?
That was not taken by the system. That was not taken by the system. We cannot do anything.
No,
The system
does
was
it
not
mean that the PAN card is wrong? PAN number is wrong?
Yes, the system was not accepting that PAN card. System was not accepting. We have already submitted by way of petition in that execution case, Lordship, but that was not considered. And right now we are.
What is the amount you have deducted?
Lordship, about 2 lakh something. we out of the total amount, we have deposited 24,29,000.
And this amount, this 2 lakhs,
Lordship,
2
we,
lakhs,
the total amount was 26 lakhs and with interest of 9%. The total amount was 26 lakhs 21,855.
and you have deducted,
We have deducted 20% of that ADS loss.
what is the amount?
We have deposited Lordship 24 lakhs 29,004 rupees.
You have deducted the amount.
Lordship.
What is the amount you have deducted?
Lordship, that calculation right now I don't have. I think they have. The calculation is not with me right now. Lordship. That is in the office.
You come prepared, then we will grant you time. You saw the relevant provision under which you were entitled to deduct the aforesaid amount.
Yes.
And whether you have deducted this amount from the interest accrued upon the principal amount,
Yes, yes. From
or from the
interest,
principal amount you have deducted it.
Lordship, I cannot say the total procedure, Lordship, that is as per the income tax. Act,
You
Lordship.
come with the procedure then,
Lordship.
as prayed for by Mr.
PJ Bond.
P.J. Burman, learned counsel for the petitioner. SSL is the matter day after tomorrow, so as to enable him to produce the relevant documents in deducting a sum of rupees 2 lakhs. Itu head to Kurla 26. Itu deduct করে যেটা amount to lie করে. From the amount, the claimants, the amount that respondents are entitled to.
Lordship, we fix next week so that I can get some time. And again,
In
note the
MSC case
relevant
number
provisions also.
32 of 2024. Okay, next Monday.
Next. Public.
Item 3. In this case, we have filed Ukalano on behalf of the private respondents, but copy of the petition is not given to us.
To you.
Yes, my lord. My fear is that a matter be taken up day after tomorrow, my lord, on Wednesday, and in the meantime, a copy may be given to us, my lord.
Okay.
There is a connected case that may be tagged as well, Your Worship. FAO,
Yes, my lord. In that case, no interim in their favor.
Lordship,
So,
that was admitted.
Okay. Heard Mr. B.J. Mukherjee, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner and 8 petitioners have put to challenge the correctness or otherwise of the order dated 24/9/2024 passed by the learned civil judge, Senior Division, Boangao, in Mijay case number 101 of 2024, arising out of title suit number 149 of 2023. It is to be noted here that by the impugn order dated so and so, the learned trial court has directed to implement the injunction order with the help of police. Mr. Sigdar, learned counsel for the learned counsel appearing for the respondent submits that he has filed Wakalatnama today,
No one. Well, before vacation, man.
submitted Wakalatnama before vacation, and that he has not been furnished with a copy of the petition. And therefore, Mr. Sigdar contended to list the matter day after tomorrow.
Okay.
Day after tomorrow. And also, in the meantime, to direct the learned counsel for the petitioner to furnish a copy of the petition to him. Here is accordingly allowed. Mr. Mukherjee shall furnish a copy of the petition to Mr. Sigdar during the course of the day.
Deep Item number 4. Here in this case, we file this CRP against the order Lordship will find at page 99. The petitioner as a plaintiff filed a suit for right title, interest and injunction along with a miscase for injunction, temporary injunction, and there was an order in favor of us granting injunction. They have filed appeal before the court, first appellate court, and there was an order modifying the interim. And against that, we have filed a revision petition before this honorable court. And in that case, this honorable court has granted stay of that order. But the respondent, they have filed counterclaim along with the injunction. And in that case, the injunction petition was rejected by the trial court. Lordship will find at page 96, Annex 10, the injunction rejected by the trial court. Against that, my lord, the opposite party have filed misappeal against the injunction, against the order of the trial court refusing the injunction, and the appellate court has vacated, set aside the order of the trial court and order for to maintain status quo. My lord, kindly have a look at the annexer 11, page 99. Here, my lord, the court, first appellate court has said that the learned court, trial court has not considered the prima facie case, the 3 golden rule principle in granting the injunction, and also not considered the claim of adverse possession. These 2 points have been discussed, and ultimately the order of the trial court granting injunction, refusing their injunction, has been modified and set aside, my lord. So, my lord, kindly have a look at the, my lord, the order of the court below. First, trial court, lordship will find the trial court at page 96. It was considered, my lord, page 96, annexer class, annexer 10. May I read out, my lord, annexer 10? My lord. The case is registered upon the petition filed by the defendant petitioner under order 39, rule 1, 2, 3 of the CPC, claim for granting temporary injunction against the opposite party's plaintiff. It is stated in the petition that the petitioner has filed counterclaim in title suit number 14/22, claiming their right, title, and interest over the suit land. It is stated that they are in possession of the suit land, but the opposite party is trying to forcefully occupy the same. Hence, it is prayed to pass temporary injunction against the opposite party. The OP in his written objection has denied the claim of the petitioner and prayed to dismiss the petition. In view of the above, I have perused the plain and counterclaim filed in case number 7. So it is seen that the suit land is on measuring 2/10 lesser shown in the schedule for the plain and counterclaim. The petitioner counterclaimant has filed counterclaim alleging that he has purchased the suit land from the plaintiff OP through verbal agreement upon a consideration of price of rupees 22,000 only. The petitioner counterclaim has also stated that
the suit property was handed over to him in presence of witnesses on 15/3/2001 by the OP. But did not furnish the details of any of the witnesses. The plaintiff OP on the other hand has denied the above claim of the opposite party and stated that he has purchased the suit land through a registered deed and never sold the suit land to the petitioner. The OP has also submitted few documents in support of his claim. On the basis of the above facts, I have visited the Transfer of Property Act 1882, Section 54 of the said Act specifically mandates that any kind of sale of the immovable property valued over 100 must be done through registered instrument. Therefore, in my considered opinion, the claim of the petitioner that he has purchased the suit land through verbal agreement does not carry the force of law. Hence, considering the matter in entirety, I am of the opinion that prima facie the case does not lie in favor of the petitioner. Therefore, as the petitioner has failed to fulfill the first golden principle of granting temporary injunction, hence I do not deem it necessary to discuss the rest of the principles. Trial court has duly considered. He has claimed that land is purchased verbally and without any sale deed, and they also did not given the details of the witnesses. So, trial court has duly considered. We have no prima facie case. Prima facie case is in our favor. We have purchased the land by a registered sale deed. And kindly have a look at their mistake.
Okay.
And
Heard Mr. Sigdar, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 CPC, the petitioner, Shivsaran Barman, has challenged the correctness or otherwise of the order dated 26/7/2024 passed by the learned civil judge, Senior Division Baksa in Miss Appeal number 1 of 2023. It is to be noted here that by the impugned order dated so and so, the learned civil judge, Senior Division Baksa, has allowed the appeal filed by the opposite parties and set aside the order dated 1/6/2023 passed by the learned Munshi Baksa in Mizze case number 1 of 2023 arising out of counterclaim of the opposite parties struck defendants in title suit number 14 of 2022. Peruse the petition on the documents placed in record and also peruse the impugned order dated 26/7/2024. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. And considering the submission of Mr. Sigdar, learned counsel for the petitioner, and also considering the given facts and circumstances on the record, the impugned order dated 26/7/2024 passed by the learned civil judge, Senior Division Baksa in Miss Appeal number 02 of 2023 stands state list after 4 weeks.
number 5 of the university.
Lordship, this is an application for setting aside the impugned judgment and order dated 28/8/24 passed by the learned additional district judge number 1, Kamrup Metro at Guwahati in Miss Appeal number 44/16, thereby dismissing the appeal and confirming the impugned order dated 22/6/16 passed by the learned civil judge number 2, Kamrup Metro at Guwahati. In this case, 387/2014 arising out of title suit number 346/2014. In a nutshell, if I say that this is a case where the petitioner was approached by the respondent for doing a business. So after he approached the petitioner and the respondent, both started a business by the name of RS Pump House. And in before prior to that, they have signed an agreement which was not registered. Then upon that, after 3 years, the tenancy expired. The room they have to rent of where they were doing the business, the tenancy expired. After expire of the tenancy, the respondent started doing business in other place, and the plaintiff started doing business in other place, and the respondent took the same place again in his name and started doing a business thereupon. So after that, the plaintiff approached the court, honorable court, and then filed a title suit bill number 346, 2014. And in that case, they have filed an application under Order 39, Rule 1 and 2, in which they were granted injunction. So the thing is, the plaintiff number 1, that is in page number 25, NHR 1A, RS Pump House. It is a co-proprietorship firm, and it is not a registered firm. And as per the law, it is said that if it is not registered, it does not have a legal identity to file any suit, to sue anyone or can be sued. So now they are filing a case under the name of RS Pump House, which is not a registered firm, and they are also getting an injunction from the same. So, well, the matter pertains that if it is a non-juristic person, it is a non-juristic person, how can a court may pass a injunction regarding the same? Or and the thing is, the respondent, who is the plaintiff, is also doing the same business in other part, and they are saying that we are hampering their livelihood. So, this order may be set aside. I have a few judgments also regarding the same, that unregistered firms do not have the right to sue or can be sued. They don't have the local standing to sue.
So may the judgment. Alright, Mr. Your good name.
As Afridi.
Yes,
Afridi.
learned counsel for the petitioner. This petition under Article 227 related to Section 151 of the Code of Civil Procedure. The petitioners have put to challenge the correctness or otherwise of the order dated 28/8/2024 passed by the learned additional district judge number 1 Kamrup M. Guwahati in municipal number 44 of 2016, and thereby dismiss the appeal and confirm the impugned order dated 22/6/2016 passed by the learned civil judge number 2 Kamrup M. Guwahati in Mizde case number 387 of 2014 arising out of TS number 346 of 2014. Peruse the petition and the documents placed on record, and also peruse the impugned order dated 28/8/2024 passed by the learned additional district judge number 1 Kamrup M. Guwahati in municipal number 44 of 2016, and also the order dated 22/6/2016 passed by the learned civil judge number 2 Kamrup M. Guwahati in Mizde case number 387 of 2014 arising out of TS number 346 of 2014. Let notice be issued to the respondent returnable in 4 weeks that be taken by registered post with ADN. With ADN also by usual process within a week from today.
A stay may be granted to the injunction. Because this is the livelihood from which they are earning money, the petitioner.
Having heard the submission of Mr. Afridi, learned counsel for the petitioner, and also considering the facts and circumstances on the record, operation of the impugn order dated 28/8/2024, passed by the learned decision number 1, additional decision number 1, Kamrup M. in Miss Appeal number 44 of 2016, and the injunction order the 22/6/2016 stands state. Place the matter after 4 weeks.
Number 6. This is your lordship, here the petitioner is the defendant number 1, and the respondent is the plaintiff. And the plaint is at page 12. The suit was filed page 13 for suit for declaration right title and interest and for confirmation of possession. My lord, here, my lord, WS is the problem. The defendant number 1, page 22, he held a WS, my lord. However, there was some delay on due to his illness and due to COVID affected period, my lord. This WS, page 22, that was filed on 5/7/2022, my lord. Impugn order is at page 28, 13/9/2022, my lord. This WS was refused to be accepted, my lord. And in fact, we have given the medical prescriptions also, my lord. And keeping in view of the stage of the suit is, my lord, kindly see, lordship, at I have given the order.
This medical document relates to which period?
My lord, yes, for that period that could not be, my lord, given. And now also he is suffering, that I have given, my lord. Now, my only submission, keeping in view of the stage of the suit, my lord.
No.
My lord,
You have to justify the reason.
that's correct.
There is no medical document.
Yes,
Hmm?
as per the order, my lord.
Not as per order, as per your document also.
Yes, my lord. And
Hmm?
that for the period, my lord, that COVID was also in force, my lord. That due to the precautionary measure, para 4, my lord. Para 4. Para 4 of my petition, my lord.
Hmm.
That is the prime reason for which that the prior.
There was an order of the Supreme Court in
Yes. Sumo to
petition number 3 of 2020.
19, my lord, 2019. And this COVID was up to, my
So
lord.
which period is excluded from that from the purview of this limitation?
Yes, my lord. Limitation will start from, my lord, 1/3/2022, my lord.
Here, you have received the notice on 23/3/2021.
18/3, my lord, page 28,
Hmm?
third paragraph, my lord. Serve on 18/3/2021. And, my lord, presently also the suit is at the stage of, my lord, WS and SR.
Maybe.
Yes, my lord.
That is not the ground for
Yes.
accepting your WS.
My lord. Moreover, my lord, that provision under Order 8, Rule 1, my lord, CPC. This is, my lord, directory, my lord.
No, that's all right.
Yes. So in that few, my
That's
lord,
all right, but you have to justify the reason.
my lord, my WS is in the record, my lord, still. Now, my lord, on medical ground, as I have given, my lord, he is still suffering.
No. Where is the
And-
medical document?
Of course, my lord, these are later date, my lord. Page 41. This is of 2024, my lord, and page 42, type copy. Original given page 43, my lord. He is a cardiac patient, 67 years age, my lord. So, my lord, for ends of justice, my lord, because all party will give the, my lord, otherwise I will suffer prejudice, my lord, if I cannot put my.
How you will suffer prejudice?
Because the land he sought for, my lord, recovery, that is already given in gift to a masjid, and masjid has given me to stay there as a tenant, my lord. So I have to place that, my lord, matter, and which is already filed
But due to, my lord, that
Let notice go at this is this.
however, my lord, that pending suit, it will be proceed further, my lord. So, my lord, may now.
Let the other side enter appearance. Thereafter, we will consider your entering here, not at this is this.
My lord, that.
Had there been medical document that, then we would have set aside the order and remand the matter to the trial court.
My lord,
But
para
there is
four-
no medical document.
my lord, keeping in view para 4, my lord, of category.
No, that is a statement.
Yes. And moreover, my lord, the judgment, just paragraph, my lord, 9,
Hmm,
small paragraph,
hmm,
given the judgment.
hmm.
It is reported in 2006, 1 GLT 678, my lord.
Hmm.
Para 9, my lord. In the recent decision, a case of so-and-so, report 2005, 6, SSC 70 appears to following in earlier two decisions. Kailas versus Nanku and reported in so-and-so. Salem Bar Association, TN versus Union of India, reported in 2005, 6, SSC 344. Opined that the court may permit filing of written statement beyond upper limit of 90 days prescribed under Order 8, Rule 1 of CPC in exceptional cases only as Order 8, Rule 1 provides that there too are directory in character and not mandatory. My lord, my bona fide may kindly say, my lord, I filed this, my lord. Of course, there was delay, my lord, but I was with my WS report on our court, my lord. Because of the, my lord, strictness, my lord, provision of Order 8, Rule 1, the court did not. However, while the matter has gone to the Honorable Supreme Court, and the Honorable High Court has taken a view in favor of the, my lord, defendants, saying that being this is a directory, not mandatory, that could have been taken, and this WS was directed to be accepted, man. Even this is the decision
No,
of
that's
our,
all right, but there must be some ground.
my lord.
In the Salem Advocate Bar Association, it is stated that the delay has to be justified.
My lord.
Where is your justification?
My lord, he filed one petition along
Here,
with the
government
WS.
in your petition will not do unless supported by some document.
My lord. Para,
Heard Mr. B.K. Das, Learned
Ma'am.
Counsel for the petitioner. In this revision petition under Article 227 of the Constitution of India, the petitioner has put to challenge the order dated 13/9/2022 passed by the Learned Civil Judge Junior Division number 1 in PS number 25 of 2021. It is to be noted here that by the impugned order dated so and so, the learned trial court refused to accept the written statement filed by the petitioner, being time barred. Whereas the petition and the documents placed on record and the impugned order dated 13/9/2022. Let notice be so to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. Interim pair of the petitioner will be considered after appearance of the respondents.
my lord, may I pray, my lord, one more. That next date is fixed on 11/11. I may take justice service, my lord. Can it be fixed prior to that, my 11/11? Otherwise, my lord, my
Okay,
prayer
after,
would be.
okay, after 2 weeks,
Yes.
justice service is
Yes.
also permitted.
My lord, all right.
Item number 7, matter for admission.
So this is a regular first appeal, my lord, against the judgment passed by the civil judge, my lord. We have approached this honorable court. The civil judge has dismissed the case of the plaintiff on the ground that the plaintiff was not able to prove any malicious prosecution. But whereas in the written statement itself, there was a plea by the defendant at page 30 that it is admitted at page 30, he himself admitted that he was removed from service on the recommendation of the defendant. So at this stage, I pray that notice may be issued and this appeal may be admitted, my lord. Case of malicious prosecution.
Third, Mr. Khan, learned counsel for the appellant. This appeal under section 96, read with section 107, read with section 151 of the Code of Civil Procedure. The appellant has put to challenge the correctness or otherwise of the judgment and decree dated 15/2/2023 passed by the learned civil judge Digubar in title suit number 62 of 2015. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and or decree dated 15/2/2023. Admit. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. Register shall call for the record from the learned trial court. List the matter after 4 weeks. I don't press go.
Item number 10.
May I please have a Lordship, this appeal filed for enhancement by impugned judgment and order dated 25/6/24 passing WPC MACT 148/2021 passed by learned MACT Borpata, your Lordship. If your Lordship will find the ground of appeal, your Lordship.
What is the amount
Your
the
Lordship,
learned member has awarded?
Lordship, 11. Amount was 12,11,000 only, your Lordship.
11 lakhs?
12,11,000. At best 14 your Lordship, 4 your Lordship. Paragraph number 5 we have listed.
The injury case or death case?
Death case, your Lordship, and the disease was the 25 years at the time of his death.
What is the monthly income of the deceased person?
As per the PW2 EDU's document, his the Honorable Court consider only 7,000, but as per PW,
He was a service holder or
service holder, private service holder. Under he was work under the PW2 year
PW?
2. And PW2 EDU's document also.
Heard, Mr. Your good name?
SI Akan, your Lordship.
Learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and order dated 25. Judgment and award dated 25/6/2024 passed by the learned member, Motor Accident Claim Tribunal, Borpeta, in MSC case number 148 of 2021 for enhancement of the compensation amount. No, for enhancement of the award. Is to be noted here that by the impugned judgment and award dated 25/6/2024, the learned member, Motor Accident Claim Tribunal, Borpeta, has directed the respondent number 3, New India Assurance Company Limited. No. The respondent, New India Assurance Company Limited, to pay the sum of rupees 12,11,000 from the date of filing the claim petition, that is 23/3/2021 till the date of realization. peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned order dated, impugned judgment and award dated 25/6/2024. Admit, let notice be issued to the respondent, returnable in force, that be taken by registered post with ED and also by usual process. Within a week from today, registrar shall call for the record from the learned member, MSCT. Barpeta, list the matter after for us.
So blessed.
Item number 11. This appeal is prepared by the claimant for enhancement of compensation lordship. Is the implication case lordship, and the permanent disability is not taken into account. Right, judgment is award dated 27/6/2024 by MSP 2 Kamru. MSC case number 1639.
Heard Mr. A.R. Agarwal, learned counsel for the appellant. This appeal under section 173 of the MB Act 1988 is directed against the judgment and award dated 27/6/2024. Hospital learned member, motor accident claim tribunal number 2, Kamrup M. in MSC case number 1639 of 2018. This to be noted here that while impugned judgment and award dated 27/6/2024, the learned member, motor accident claim tribunal number 2, Kamrup M. in MSC case number 1639 2018 has directed the respondents to pay a sum of rupees 13,07,543, being the compensation to the appellant.
9%.
With interest at the rate of rupees 9% per annum. Peruse the memo of appeal and the grounds mentioned therein. From the date of filing the claim petition, that is 9/8/2018 till realization. Peruse the memo of appeal and the grounds mentioned therein.
Yes, Lord.
And also peruse the impugned judgment and award dated so and so. Let notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within our come today.
Appeal may kindly be admitted also, and the records may kindly.
Registrar shall call for the record. Admit the কথা বলো না? Admit. Registrar shall call for the record from the learned member, MSCT. Kamrup. MSCT number 2, Kamrup M. Guwahati. List the matter after 4 weeks.
12.
This is an appeal filed by the insurance company also. In this case, this was a minor, and he was riding a motorcycle at the 11th time of accident also.
He was?
He was a minor also,
Hmm.
and he was riding a motorcycle at the 11th time of accident in a public place.
What was the age?
It's 16 years.
16. Is there any document in support of the age?
Actually, we adduce evidence. We adduce evidence that he was a minor also. He did not have any driving license.
Heard Mr. K.K. Bhatt, learned counsel for the petitioner, no, appellant. This appeal under section 173 of the MP Act is directed against the judgment and award dated 3/6/2014. Hospital learned member, MSCT. Nagaon, in MSC case number 301 of 2018. It is to be noted here that by the impugned judgment and award dated so and so, the learned member has directed the appellant, New India Assurance Company Limited, to pay a sum of rupees 10,52,800, being the compensation with interest at the rate of rupees 6% per annum from the date of filing the claim petition till realization. Mr. Bhatt, learned counsel for the petitioner, on the appellant submits that the deceased was a minor and the accident took place while he was riding a motorcycle at a public place without driving license. And as such, the impugned judgment and award dated so and so is illegal and arbitrary, and therefore it is contended to set it aside. The submission of Mr. Bhatt needs further consideration. At this stage, admit the appeal, show notice to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Dismissal call for the record from the learned member, MSCT Nagaon. List the matter after 4 weeks.
I for the state. We deposit 50%. We deposit 50%.
50%. For Mr. Bhatt, learned counsel for the applicant. This interlocutory application is preferred by the applicant New India Assurance Company Limited for staying operation of the judgment and award dated 3/6/2024 passed by the learned member MSCT Nagaon in MSC case number 301 of 2019. Mr. Bhatt, learned counsel for the petition, appellant submits, applicant submits that the applicant has preferred an appeal being MSC appeal number 57 of 2024, and the same has already been admitted by this court, and notice has been issued and the record has already been called for, and that the applicant is ready to deposit a sum of rupees deposit 50% of the awarded amount before the rest day of this court, and therefore Mr. Bhatt contended to stay operation of the impugned judgment and award dated 3/6/2024. Further, Mr. Bhatt submits that the deceased was minor at the time of accident and he was riding a motorcycle without driving license at a public place. And as such, the impugned judgment and award is illegal and arbitrary, and therefore it is contended to stay operation of the impugned judgment and award dated so and so. Further, having considered the submission of Mr. Bhatt, learned counsel for the appellant, and also considering the facts and circumstances on the record, operation of the impugned judgment and award dated so and so instance state till disposal of the appeal, subject to the condition that the appellant shall deposit 50% of the awarded amount before the rest day of this court within a period of 15 days from today. In terms of this instance disposal.
Item 13.
Claimants, the petition of the claimants has been dismissed by the learned tribunal logic on the ground of lack of jurisdiction logic. In the month of July 2023, it was registered without examining the materials on record or without giving the opportunity to the claimants to bring on record certain regarding the address and other materials. It has been straightaway rejected by the learned tribunal on the ground that
they fail to bring on record any material showing the address falling under the jurisdiction of Gwalpara, MSCD Gwalpara Lordship. Lordship, in fact, as per my instruction, prior to the date of the deceased, they have been residing in Gwalpara Lordship due to the business or the other occupation of the deceased Lordship. And the address has been mentioned in the claim petition Lordship, although they were the permanent resident of Kokrajhar Lordship. So under section 166(2), so the law is very clear also. And we have given one written argument also to that effect, and that was not considered also. So it may be admitted also for consideration.
Where is the impugn order?
Impugn order is material part is page 20 Lordship, starts from page 19.
Where the accident took place?
Accident took place at Palazan Zeli Road, Kokrajhar Lordship. But they were the residents of the given address in Agia Lordship, which falls under the jurisdiction of MSCD Gwalpara Lordship.
So in fact, you belongs to Kokrajhar district.
Originally, permanently, they were the resident of Kokrajhar district also, but due to the occupational purpose of the deceased, as per my instruction, prior to the date of the deceased, they were living in the given address also at Agia.
You show the documents that
Lordship,
you were residing in Agia and carrying out business there.
No, Lordship, the tribunal did not give that opportunity also, Lordship.
No, you produce the documents before this court, we will see.
And Lordship, regarding the jurisdiction, Lordship, law is very clear, Lordship. We have specifically mentioned is in our written memorandum, Lordship, at page 12. Paragraph 3, Lordship, of the May I read, Lordship. That regarding jurisdiction, subsection 2 of section 166 of the MB Act stipulates that the claim petition can be filed at the option of the claimant, either to the claim tribunals having jurisdiction over the area where the accident took place, and to the claim tribunal where the local limits or whose jurisdiction the claimant resides or carries on business, or within the local limits of whose jurisdiction the defendant resides. Moreover, in a landmark judgment of the Honorable Supreme Court in Malti Devi versus National Insurance Company Limited on 5th of January 2016, it was held by the learned by the Apex Court that the provision of territorial jurisdiction has to be interpreted consistent with the object and facilitating the remedies of the victim accidents. Hyper-technical approach in such matters can hardly be appreciated. There is no bar to a claim petition being filed at a place where the insurance company, which the main contesting party in such cases has the business. In such cases, there is no prejudice to any of the party. There is no failure.
Tell me, is there any office of the insurance company at Gwalpara?
No, Lordship. The Solamandalam insurance company is not having no setup in Gwalpara, Lordship. Even Lordship, nowadays in some of the insurance companies, they don't have the setup in even in Assam also. Most of the some individuals purchase the insurance policies online also. So everything goes on goes via online also. At page 13 also we have placed our argument that in a very recent judgment of the Honorable Guwahati High Court in Sandipan D versus MS Chaudhary Commercial and another, the Honorable Guwahati High Court had held that the jurisdiction of Motor Vehicle Claims Tribunal is wider than the Civil Code, and the Code of Civil Procedure is not applied with its full rigor in a proceeding.
Mr. Das, you produced the document that you were residing temporarily at Agia and carrying out business there.
Lordship, assuming Lordship, there is a suppose there is no document. Assuming Lordship, even though Lordship, it cannot be a bar for the MSA tribunal to proceed with. Lordship.
No, that's all right. You have claimed that you were residing at Agia.
As per my instruction, Lordship, they were since the date
If
of
they are residing in a rented house, you show me the document.
Lordship, to that effect, I'll have to take instruction because on records there is nothing.
Because in that case, if you have any document in support your claim,
Lordship.
then we will set aside the order and remand the matter to the trial court.
Lordship, even though the claimants cannot fail to produce any document, Lordship, in that case also the claimants can proceed, tribunal can proceed, Lordship. So I'll satisfy your Lordship. I'll satisfy your Lordship.
Oh, we'll fix a short date.
Lordship.
When?
Lordship, on
Next week?
Monday, Lordship.
On 30, on 30 Wednesday.
As read for by Mr. D. Das, learned counsel for the appellant. Rest shall list the matter on
30 October. Wednesday.
13.
30.
So as to enable Mr. Das to produce some documents in support of the contention that the petitioner was temporarily residing at the relevant time of accident at Agia of Gwalpara and carrying out business there.
Lordship, I'll satisfy your Lordship that even if the claimants fail to produce any document, the tribunal can proceed. Lordship. In that,
Okay,
Lordship.
you produce the relevant documents, we'll see.
Item 14.
Yes,
This is an appeal by the claimant
by the claimant.
against dismissal of his claim petition.
What is the ground for dismissal?
On the ground that there was a delay of 6 days in filing the claim petition, and there was a petition for condonation of delay. And page 41,
When the accident took place?
accident took place on 11/2/2023.
So after coming into operation of the new
Yes,
act.
yes. And then claim petition was filed on 11/8/2023. There was a delay of 6 days. I have explained in my petition before the tribunal why the delay has occurred. Number one, my
No,
lord,
problem is that
Whether
in the
it be-
section it has not been provided.
my lord, there is a counter argument to that effect, my lord. Section 29(2) of the Limitation Act, which states that if a particular statute provides a particular period of limitation, then the period of limitation prescribed in that act will be followed. And thereafter, for the purpose of determining the period of limitation, if there is a condonation application, then the entire sections from section 4 to 29 of the Limitation Act will be applicable. So if that is the position, madam, then the tribunal ought not to have dismissed my petition. And secondly, my lord, that
No,
act
the
cannot
matter
be-
is pending before the Supreme Court.
Yes. Right now it is pending before the Supreme. But may kindly examine
Whether it is a death case or
injury case.
injury.
Injury case. I was in a bedridden
Whether any
condition.
case has been registered or not, police case?
Yes, yes, police case registered
When?
in Boku police station.
Whether the officer in charge of jurisdictional PS has forwarded copy of the accident information report to the claim tribunal
No.
or not?
No. That is the plea I have taken. That within 3 months, he is duty bound to send it under section 159 of the FDL before the tribunal. But that he has failed to do. And thereby I am being deprived. That Boku PS page 27 is the form 54, which he has given me belatedly, and therefore the delay has occurred. This is the main reason for which I could not file within time. This is Boko PS case number 197 of 23.
Who lost the FIR?
Pardon.
Who lost the FIR?
My lord, yes. My lord, my son, my lord.
When it was lost?
In my petition, I have before the tribunal, page 22. Paragraph, page 23, paragraph 2, I have informed that one Rafiqul Islam, son of Habez Ali, lost the FIR on 4/5/2023. Since the claimant was in a bedridden condition.
When the form 54 was furnished to you?
I received it on 16/8/2023. And I filed on 17/8, on the very next day. I have stated in paragraph 2, page 4.
Okay, we will implement the state of Assam as party in this proceeding. Then we will issue notice.
Right.
We will inquire why the accident information report could not be furnished to you in due time.
Yes.
Third, Mr. Bhattacharya, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act is directed against the order dated 3/7/2024, passed in Ms. J case number 3 of 2023, as well as the judgment and order dated 3/7/2024, passed in MSC case number 98 of 2023, passed by the learned member Motor Accident Claim Tribunal at Aminggaon. It is to be noted here that by the impugned judgment and award dated 3/7 judgment and order dated 3/7/2024 in MSC case number 98 of 2023, the learned member has dismissed the petition on the ground that there is delay of 6 days in filing the claim petition. Mr. Bhattacharya, learned counsel for the appellant, submits that the accident took place on 11/2/2023 and the FIR was lodged by the son of the claimant on 4/5/2023 before the officer in charge Baku Police Station, on receipt of which Baku PS case number 197 of 2023 under section 279 338 IPC has been registered. And thereafter, a request was made to the officer in charge concerned police station for furnishing accident information report, that is the form 54, but the same was not furnished to the son of the claimant. And in the meantime, the limitation period of 6 months over. And as such, a hearing was made before the learned member MSCT Kamrup at Aminggaon for condonation of delay of 6 days, but the same came to be dismissed by impugned order dated so and so and so. In view of the submission of Mr. Bhattacharya, learned counsel for the appellant, this court is inclined to implement the state of Assam as respondent number 4 in this petition, in this appeal, respondent number 3 in this appeal. Let notice be issued to the newly implemented respondent and also to the respondent number 1 and 2 by registered post and also by usual process within a week from today. Step be taken by registered post with AD and also by usual process within a week from today. Place the matter after 2 weeks.
That's a appeal for enhancement also.
Hmm.
The disability of 30% was not considered by the learned tribunal also.
Have you produced any disability certificate?
Yes, Lordship, it has been proved by the PW2 also. The doctor,
Whether it was issued by a board or doctor,
yes, board, Lordship.
individual doctor,
Board, Lordship.
board. Why it was not considered then?
Trial court has given the reasoning that it is not a sustainable disability as per the view of the planet tribunals.
Sustainable?
It is not a sustainable disability. It will not affect the business future course of the claimant.
What was his profession?
Is a driver, lots of professional. No, lots of he's a petty businessman also. I'm
Petty businessman.
Lordship.
For Mr. Didas, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 21/6/2024, passed by the learned member MSCT Golpara in MSC case number 70 of 2020. It is to be noted here that by the appeal judgment and award dated so and so, the learned member MSCT Golpara has directed has awarded a sum of rupees 93,774 being the compensation to the claimant. Mr. Das, learned counsel for the appellant, submits that the appellant had sustained grievous injuries on account of the accident, and a disability certificate was also produced before the learned member MSCT Golpara, but the learned member has not considered the same. And as such, this present appeal is preferred for enhancement of the awarded amount. Be that as it may, and this is this, admit the appeal. Let notice be issued to the respondents returnable in 4 weeks. That be taken by registered post with AD and also the legal process within a week from today. Dismissal call for the record from the learned member MSCT Golpara. List the matter after 4 weeks.
Item number 16.
Wait, please, Lordship.
Hmm.
Lordship, this is regarding that admission into RIMC, my lord. This came up on 3rd of October.
Yes.
There was a direction given by Lordship.
What happened thereafter?
He has not been admitted, my lord.
Why?
I have instructed the developments on 5th of October itself.
Pardon?
On 5th of October itself, I have mailed them informing the observations which were taken place during the last hearing.
Hmm.
As on date, I have not received any reply. I have tried to call them also, but there has not been any correspondence from their side.
Then we will make observation. We will dispose of the petition,
Yes, my lord.
making observation regarding your conduct and also regarding the arbitrariness. And thereafter, it will be read as a precedent in other cases also. That's why on that day, we have instructed you.
But I have my side, not have same day itself I have instructed them that necessary actions will be taken because the petitioner is at serial number 29. And Lordship has asked the query whether there is any other reserved candidates above the petitioner.
There was no other
There
candidate.
was no other paragraphs, my lord, that two documents which were made part of the record, my lord, therein, my lord, the respondents have clearly stated that Harshit Shandilia is the last candidate.
who was at serial number 29. Now, my lord, after this one candidate has been withdrawn, my lord, he makes up the within the zone of 28 candidates who have been selected. And second, my lord, difficulty was whether in the midst of the session, whether the candidate can be admitted. For that also, my lord, there is a provision, paragraph 11F.
It can be till the month of November. Then where is the impediment? You tell me. Hmm?
The main payment can be taken up to, I will just have a word once again, because I've already made one of me take up it to.
No, you see, Mr. Gupta, on the other day, we could have disposed of the petition. If we made any observation regarding all this allegation, this assertion, these averments made in this petition, it will discredit you.
Yes. For
That's
that,
why we have asked you to admit him and to apprise this court about such admission. But you have not availed the chance I have given to you.
keeping that thing in the point, my lord, may I pray, my lord, can it, two, my lord, will take it up, my lord. It may happen that they may give a positive direction.
Add to that, let him apply.
Yes, my lord. Only one thing is that, my lord, admission has to be, the cutoff date for admission is 1st of November. 1st of November, and today we are on 21st of October, my lord. 10 more days to go, my lord. That is, my lord. Not entire month of November. It is up to,
Yes,
as per the SOP they have provided.
yes. Let him obtain it.
Yes, my lord.
Recorded responding 4 and 5.
Pardon?
Be recorded for responding 4 and 5.
Respondent number?
4 and 5.
No, we are not passing the order right now.
Sentence for hearing under order 41 rule to secrecy order number 17.
The extensive question of law, my lord, and submitted.
No, you are submitting it separately. Is it not part of your memo of appeal?
Earlier we used to submit the hearing also.
Not earlier. You see section subsection 3 to section 100 CPC.
Now I have said it, but my lord, after going through the records, after filing, my lord, again, I have managed to get it.
You incorporate it in your memo of appeal. Otherwise, we will not consider it. You file amended memo. Heard Mr. Kolita, learned counsel for the appellant. This appeal under section 100, read with order 41, rule 1 of the Code of Civil Procedure is directed against the judgment dated 16/5/2024 and the decree dated 30/5/2024 passed by the learned civil judge Borpeta in the title appeal number 47 of 2022. Thereby dismissing the appeal and affirming the judgment dated 4/7/2022 and the decree dated 5/7/2022 passed by the learned Munsip number 2 Borpeta in title suit number 84 of 2015. Peruse the memo of appeal and the grounds mentioned therein. Admittedly, the substantial question of law has not been incorporated in the memo of appeal, and Mr. Kolita, learned counsel for the appellant, has submitted it in a separate sheet before the court today. Subsection 3 to section 100 of the CPC mandated that the substantial question of law has to be incorporated in the memo of appeal. In view of above, it is provided that Mr. Kolita shall file amended memo of appeal incorporating the substantial question of law in the same. I'll list the matter after 1 week.
Next Monday, kindly.
List the matter next Monday.
On 28. Okay. Matter number 18.
I believe nothing. I have filed this RSA on substantial question of law matter. Case number 6 matter. The brief fact of this case is that matter. The respondent number 1, that is plaintiff, filed a title suit before the municipal one Dhubri matter. On 4/3/2023 matter, the Honorable Municipal Court was pleased to pass the judgment and decree in favor of appellant, that is defendant number 2 matter. Stating that matter, that is case number matter 39 matter. Page number 39.
Page number
39. 39 matter. That is para number 35. May I read matter? Page number 39. Therefore, only because name of the plaintiff has been mutated in the Jamabandi, he cannot claim title of the land unless he can prove that he had validly acquired the title and ownership over the land. He bases his title over the suit land as tenant on registered cell deed number 433/12 and proof is due execution as per the registration act. But even though the cell deed is duly executed, but contents of the cell deed is more specifically the right of the defendant number to sell the suit land is in question. Burden to prove the same was on the plaintiff, and plaintiff has failed to prove the same. Well, the plaintiff could not prove that his right over the suit land and the purchaser, that is defendant number 1, has the right to sell the suit land. On this ground, the learned trial court dismissed the plaintiff of the respondent number 1, that is plaintiff. Page number 38, that is Lab Mundal. There, this is one of the substantial question of law involved. And page number 38, para 33, 38, third line, from the top, page 38, The Latmundal Goripur Circle has affirmed that the exhibit tally with their records. However, names of the legal heirs of Awal Sheikh has not been recorded. PWNN2 themselves admitted that when the sale was executed, land was still recorded in the name of Awal Sheikh. Therefore, exhibit also failed to show that defendant was in possession of the suit land, as the suit land had fallen into his share in the family settlement. Here,
the original Patadar was Awal Sheikh Malik. He has legal hairs. One of my lord respondent another is respondent number 2, my lord, Qaisar Ali. My lord, when the land was sold to the plaintiff, the land was has not been was recorded in the name of Awal Sheikh. My lord, the respondent number 2, my lord, has no right title interest over the suit land, though he has sold the land, my lord. This is one of the substantial question of law, my lord, page number 6, my lord.
So you have suggested as many as 5 substantial question of law. Which according to you are essential?
Lord, one, my lord, when land was sold to the plaintiff, the seller has no right title interest over the suit land as well as possession of the land. It is clearly stated by the PW4, my lord, that is Lakh Mandal of Goripur Revenue Circle, my lord.
So this question number 1
Yes, ma'am.
is sufficient.
Sufficient, my lord.
Heard, Mr. Your good name?
That's Islam, my lord.
Learned Counsel for the Appellant. This appeal under section 100 of the CPC is directed against the judgment dated 16/3/2024 and the decree dated 13/3/2024 passed by the Learned Civil Judge Senior Division Dhubri entitled appeal number 4 of 2023. Is to be noted here that by the impugned judgment and decree dated so and so, the Learned Civil Judge Senior Division Dhubri has set aside and reversed the judgment and decree dated 4/3/2023 passed by the Learned Munchip number 1 Dhubri entitled suit number 101 of 2014. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and judgment dated 16/3/2024 and the decree dated 13/3/2024 passed by the Learned Civil Judge Senior Division Dhubri entitled appeal number 4 of 2023. And also peruse the judgment and decree dated 4/3/2023 passed by the Learned Munchip number 1 Dhubri entitled suit number 101 of 2014. This second appeal is admitted on the following substantial question of law. Number 1, whether the Learned First Appellate Court was justified in allowing the appeal. While there was overwhelming evidence of PW1 and PW2, which conclusively proves that when the sale deed number 433 of 2012 was executed, the land was still recorded in the name of Mr. Awal Sheikh, Syndicate, father of the respondent, stroke defendant number 1. Issue notice to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. SC shall call for the record from the learned courts below. Place the matter after 4 weeks. Pardon?
IA, 3157. Which is 4 is 2, madam.
For Mr. So-and-so, learned counsel for the applicant. This interlocutory application under Order 41, Rule 5 of the CPC is preferred by the applicant for staying operation of the impugned judgment and decree dated 16/3/2024 and 13/3/2024 passed by the learned civil judge, Senior Division Duburi, entitled Appeal number 4 of 2023. It is to be noted here that by impugned judgment and decree dated so-and-so, the learned civil judge, Senior Division Duburi, has allowed the appeal and set aside the judgment and decree dated 4/3/2023 passed by the learned Munsib number 1. Duburi, entitled suit number 101 of 2014. The learned counsel for the applicant submits that connected appeal has already been admitted by this court and notice has been issued to the respondents. And in view of above, Mr. So-and-so learned counsel for the applicant submits that operation of the impugned judgment and decree dated so-and-so may be stayed till disposal of this appeal, disposal of the connected second appeal. But having considered the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, this court is inclined to stay operation of the impugned judgment and decree dated so-and-so till disposal of the appeal. In terms of above this, I instance disposal.
Item 19.
Wait, Lordship. This is in second appeal against the judgment and decree passed by the learned additional district judge, my lord, Romia, my lord. This is judgment of reversal, my lord. Originally, the suit of the plaintiff was dismissed. Court reversed the judgment and decreed the entire prayer of the plaintiff. My lord, here in the appellate judgment, my lord, the learned additional district judge, my lord, given the entire burden on the defendant to prove the case of the plaintiff. It is very strange, my lord. Your lordship, maybe please to note that plaintiff purchased the land in the year 2008. And prior to that, my lord, the defendant number 1 purchased one plot in 1999 and one plot in 2007. His mutation was earlier to the purchase of the plaintiff. Now, my lord, plaintiff.
You show me the relevant observation of the appellate court.
Your lordship, first, your lordship, may be pleased to come to the judgment of the Munship, my lord. I will point out at page 29, my lord. Here, my lord, issue number 4, whether the plaintiff has been dispossessed by defendant number 1 from the land of that number 168 measuring approximately 12 blessers by constructing a road of 8 feet in breadth and boundary. Your lordship may come directly to para 10, my lord. Para 9, my lord, it will be important, my lord. In his evidence,
in affidavit, the PW1 stated that after the national highway was upgraded to 4-lane, a majority of people started constructing connecting roads from their houses to the highway. In furtherance of such a desire, on 4/1/19 and 2009, defendant number 1 illegally entered the suitland. My lord, this highway was constructed covering the entire plots, my lord. Some lands of the plaintiff, some lands of the defendant went to the highway, my lord. That is a 4-lane. Now your lordship may please to come to page 10, para 10. Further, the allegation regarding construction of road by defendant number 1 was completely demolished during the cross-examination of PW1, where he categorically admitted that since the year 1999 till the date of his deposition in the court, defendant number 1 has been using the road constructed by one Narayan Mallik. PW1 also admitted that he himself and his tenants have been using the very same road, and there is no alternative road for his land to the highway. Now, apparently, as per PW1's own admission, the road in question has been in existence since the year 1999. Therefore, the allegation that defendant number 1 constructed that road on 4/1/2009, thereby dispossessing the plaintiff from his land, does not hold water, and the date of actual cause of action seems fictitious. More so, normally a person would have reacted by lodging a police complaint in connection with the alleged encroachment, which does not appear to have been done by the plaintiff. My lord, this is a case regarding a road, my lord. The plaintiff stated that after his purchase, defendant number 1 started a new road to the highway that is 12 feet approximately. He cannot say even the details of the land also. The learned appellate court, my lord, in a different way, gives the burden on the defendant that it is the defendant case he is to prove that this road belongs to him. Your lordship may be pleased to see appellate court judgment. It starts from page 15, my lord. My learned appellate court, my lord, did not discuss any of the evidence of this judgment and any of the evidence of the PW1, my lord. He stated whichever is required for passing the judgment in favor of the plaintiff, my lord. Here, my lord, page 15, last para, my lord. In the cross-examination, PW1 stated that he purchased the land on 2/7/2008, and his owner has measured the land by Latmondal before purchasing, and then was 2 Katha. PW1 further stated in cross that before purchasing the land, SDOC civil and the Latmondal erected the post. PW1 further stated in cross that the road used by Horendaka, that is the defendant number 1, who is the appellant before your lordship, by which highway is reached, his tenants means the plaintiff's tenants, my lord. His tenants also uses the same, and besides the road, there is no road connecting the highway from his road. This is an admitted position, my lord. The learned appellate court also admitted. But now he want to say, my lord, this road belongs to the plaintiff, and a road was constructed over the land of the plaintiff, and that is the only road which is used since 1999 by the defendant number 1 after purchasing his land. Defendant plaintiff came to the land only on 2008, and thereafter also, your lordship, that record will reveal, my lord. I can read from the evidence, my lord. The other defendants also stated the same thing. PW2 also stated the same thing, that the road was in existence since 1999. Now plaintiff want to say that the 12 acres of land were encroached by the defendant number 1, and he constructed the road. That is totally false. And the learned appellate court has shifted the burden. Here, my lord, your lordship may be pleased to see at page 19, my lord. Dags are totally different, my lord. His dag is different dag, my dag is different dag. Page number 19, my lord. on the top, my lord. Defendant has submitted that he has been residing in DAG number 155 and he has not encroached the road as the road was in existence before his purchase of 10 acres of land in DAG number 155. But defendant failed to prove the same in his cross-examination. It is the case of the plaintiff, my lord. Plaintiff is to prove. The law is this. Well, now, my lord, the appellate court stated that the defendant is to prove. And his land, the defendant number one's land was mutated prior to the purchase of the plaintiff, my lord. Plaintiff purchased the land on 2/7/2008 and mutation of the defendant number one was on 9/5/2008. That means 2 months prior, he purchased that. And apart from this, my lord, the learned appellate court discarded the judgment of the learned mercy on the point. Plaintiff stated that the land was measured and there was on 4 corners of the road posts were put by the Mondal. Even the vendor of the plaintiff was not there at that time. And the learned appellate court says that Mondal is not required, that whether he has delivered the possession of his purchased land, that is 2 quarters of land. So my humble submission before your lordship that this is a judgment of reversal. Apart from that, my lord, that there is total perversity in the judgment. A record will be necessary, my lord, to prove, and I have the evidence, my lord, I can read before your lordship, my lord, that what it is admission stage. I have, my lord, given the substantial question of law at page 5. Whether the suit is bad under section 34 of the specific relief act for not paying the cancellation of the sale deed of the defendant number one. Because the defendant number one purchased his plot at DAG number 155 and the plaintiff land is DAG number 168. And he purchased subsequent, my lord. So in the prayer portion of the plain, my lord, he not challenged that the deed of the defendant number one is required to be cancelled, my lord. Here there is no such prayer. Only his prayer that he may be delivered, declared title regarding right title and possession over the scheduled land. That is that passage, my lord. Then second substantial question of law, my lord, whether the suit is brought for non-joiner of all the partners of NK partner number 1 and 6, as the suit involves boundary dispute and all the partners use the road in question since 1999. But the plaintiff purchased his land only in 2008. Plaintiff purchased, my lord, in 3 DAGs, 166, 167, 168. Learned Munship, my lord, observed. But he prayed only in the 168 DAG, which is adjacent to DAG number 155. So all the partners of both the partners are required. Then, my lord, third number, whether the suit is a public road used by all the partners and that the land of all partners were acquired by government for construction of national highway, after which area of partner land reduced, which the plaintiff is trying to make by alleging the land of the road is his land. Then next, my lord, whether the judgment passed by the land appellate court is perverse, as the court totally ignored the principles of law of evidence on record. Then whether the possession of the suit land which consists of the road existed at the time of delivery of possession of the land of the plaintiff's land. After measuring by Latmondal, who was not examined, and the appellate court ignored the vital fact.
All right, now you tell me which substantial question are essential to decide this appeal?
My lord, substantial question 1, 2, 3, and 5 is necessary, my lord. And the perversity is there, my lord. Actually, according to me, this question also is required, my lord. All are important, my lord. It is up to your lordship.
Yes.
My lord, matter may be admitted. Record may be called.
Pardon, sir, P.K. Koleta. learned senior counsel assisted by Mr. Learned counsel for the appellant and Mr.
G Imtiaz, my lord.
G?
G Imtiaz,
G. Imtiaz, learned counsel for the respondent.
respondent number 1.
Respondent
Affiliated
number 1. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree passed by the learned additional district judge Romia dated 28/7/2024 entitled appeal number 9 of 2016. It is to be noted here that by the impugned judgment and decree dated so and so, the learned appellate court set aside the judgment and decree dated 18/8/2016 passed by the learned Monsif Romia in titles of number 18 of 2012. Dismissing the suit of the plaintiff. Where is the memo of appeal and the grounds mentioned therein? This appeal is admitted on the following substantial question of law. Number 1, whether the suit is bad under section 34 of the Specific Relief Act or not making any fair for cancellation of the sale deed of defendant number 1. Number 2, whether the suit is bad for non-joinder of all the pattatars of NK patta number 1 and 6 of the 1 and 6 as the suit involves boundary dispute and all the pattatars use the road in question since 1999. Whereas the plaintiff had purchased his land only in the year 2008. Number 3, whether the suit land is a public road. Oh, it is a question of fact. It cannot be a question of law. This number 3.
Number 3, my lord, actually, all the defendants and the witnesses prove that this is a public road, but the plaintiff claimed that the land belonged to him. That's why, my lord, I have given this.
No, you tell me, is it a question of law?
Mixed question of facts and law, my lord. Because after the construction of the national highway, land went to the highway, my lord. But plaintiff claimed that this land was occupied by the defendant number 1. It will automatically come, my lord, in other questions, my lord. 4 will be essential, my lord.
Okay. Number 3, you take down whether the judgment passed by the learned appellate court. Whether the judgment passed by the learned first appellate court is perverse, as the same was passed ignoring the principle of law and evidence on record. And number 4, whether possession of the suit land, which consists of the road, existed at the time of delivery of possession of the plaintiff's land after measuring by Latmandal, who was not examined, and the appellate court ignored the said fact in deciding the appeal. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with ID and also by usual process, whatever from today. Since Mr. So-and-so, learned counsel appearing on behalf of respondent number 1, no formal notice is required to be issued. However, extra requisite copy of the memo of appeal be furnished to him during the course of the
Already you have furnished. Already. Only that.
Dismissal call for the record from the learned trial court, as well as first appellate court, and list the matter after 4 weeks.
In which case, regarding stay, my lord. This is the only road used by the defendant number one for his immigration case.
Okay, till disposal of the appeal. Yes, high essence disposal. Caveat, yes. What we heard. Extensive research. Okay.
Judgment may kindly be stayed, my lord.
Higher disposal.
Item number 20. Good.
I have filed this RFA, instruction for customer from page number 9. The brief of this case is that, madam, the father of the appellant, that is main defendant, madam, was the original patadar of a plot of land 1 biga 2 kata 7 nation. Out of which, madam, 1 biga was sold to respondent number 1, that is Rukiton nation. Page number 48, madam. Page number 48, 3 minutes.
Page number?
48 minutes. 48. That is exhibit C. Is the certified copy of registered sale deed number 1545/79, dated 6/10/79. Exhibit C is the registered sale deed number of 1979. As per this sale deed, the father of the appellant, means defendant, told 1 kata, 1 biga of land out of 1 biga 2 kata 7 nesters of land. Thereafter, there was an oral exchange of land between the father of the appellant, that is Montaz Ali, and respondent, that is respondent plaintiff, that is Rukiton Nesa, regarding 1 katas of land, in doc number 273 and patta number 226, and doc number 278 and patta number 95, followed by the delivery of possession, Thereafter, appellant main defendants has been residing in the suit land from last 35 years. Page number 62. 62. Para number 6. May I read, that in issue number 3, regarding the determination of bar of limitation, the plaintiff is barred by law of limitation, as the plaintiff himself admitted that he has no possession over the suit scheduled land. The plaintiff himself admitted, that is Rukiton Nesa, that plaintiff not possession over the suit land, and suit land is under the possession of defendants. That is appellant, present appellant, for the period of more than 35 years till today. This fact is admitted by PW2. That is PW2 is also the witness of PW1. That is Rukiton Nesa. Here is defendant number 1, in their cross examination, he also admitted that the appellant and main defendants has been residing in the suit land from last 35 years, because there are an exchange, oral exchange, page number, 47, that is another exhibit, exhibit B, page number 47,
Exhibit?
Exhibit B, my lord. Page number 47, my lord. Bottom, my lord. Bottom line. Defendants exhibit, my lord. That is A and B. B, my lord. B is the certified copy of Jamabundi under periodic patta number 2 to 6 of village Tangagaon, my lord. This is the very important, my lord, exhibit submitted by the appellant main defendant, my lord. According to this exhibit, my lord, the Rukitan Nasa, my lord, that is present respondent number 1, my lord. He purchased 1 bighas of land, but he mutated 1 bigha, 1 kata, 14 lessons of land, my lord, in the year of 1993, my lord. My lord, he could not show any registered sale deed, the remaining 1 kata, 14 lessons, my lord. It means, my lord, there are.
Okay, at this instance, we will admit the appeal. Heard Mr. Swinson, learned counsel for the appellant. This appeal under section 100 of the CPC is directed against the judgment dated 22/7/2024 and the decree dated 25/7/2024 passed by the learned civil judge senior division Barpeta in title appeal number 21 of 2022. It is to be noted here that by the impugned judgment and decree dated so and so, the learned first appellate court has upheld and affirmed the judgment and decree dated 17/3/2022 passed by the learned Monsip number 1 Barpeta in title suit number 103 of 2014. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated so and so, so and so. This appeal, second appeal, is admitted on the following substantial question of law. So, which according to you are important in this appeal?
Page number 9, my lord, 1, my lord.
1.
Yes, my lord.
Whether the learned first appellate court was justified in allowing the appeal of the respondent struck plaintiff, whereas the plaintiff had failed to prove that she had purchased 1 bigha, 1 katha, 14 lessa of land from one Montazali, the father of the appellant struck defendant, by exhibiting registered sale deed before the learned court below. Let notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with ID and also by usual process within a week from today. Recessal call for the record from the learned courts below. List the matter after 4 weeks.
There is an IMS police station.
Let the other party appear, we will consider.
3159.
Issue notice. Returnable in 4 weeks. Step be taken by registered post with ID. Next date we will consider.
21.
Your Lordship, learned counsel, Mr. PP Das is unlike, the matter we passed over today, Your Lordship.
Yes, read for by Mr.
Hello.
Hello, learned counsel appearing on behalf of Mr.
PP Das.
PP Das, learned counsel for the appellant. Recessal is the matter. When? Day after tomorrow?
Next week.
Next week. Next Monday.
Item 39.
On the last occasion, Lordship, they have submitted the objection, Lordship. I think that the objection, Lordship, only 2 things were comes out, and the court told them to swear what are the other grounds for arresting me, Lordship, in this case. two things should come out, only having the statement of the co-accused and procedural lordship. And behind the bar till date lordship is 1085 days lordship. I'm sure there is in this case lordship on 25/10/22 lordship. In this case, already till date lordship, 2 witness examined, and more 6 witnesses have to be examined lordship. On having an order dated on the last order lordship, that is the second time bail application lordship. On the last time lordship, it was given in direction that for having a speedy trial to the accused lordship. I have annexed an order there lordship, it's called order lordship, on page number 101 lordship. Start from 101 lordship. Is a clear having thing that lordship. On that times also I have submitted the court that lordship on the only on the basis of the call data record. Call data record and the 67 statement lordship my arrest was shown, and till the court was at that times also court was vacant lordship. So the honorable court given direction to do a speedy trial lordship till date. It was filed having all this was the order of lordship 25/11/2022 lordship. Now the present in the trial
When the charge was framed,
Was framed on 17/2/2024.
17/2/24.
Lordship.
Examining the remaining 8 accused, another 2-3 years will be required to complete the trial.
Probably not.
Probably not. You cannot definitely say that we will complete the trial within such and such period.
Another problem is that only there is no designated court for NDPS case.
No, that is there, but on that ground, you cannot keep the person behind the bar for indefinite period.
Lordship, here, Lordship, please to see my objection, page 106, paragraph 8, 9, 10. 106, paragraph 8. Then we have given a table of involvement of the present petitioner at page number 108.
Okay. Last page तो last page
108 is the table. Paragraph 12. Lordship. Objection. There is the record.
You are referring to page number?
Page 108.
Yes.
Paragraph 12. That on the basis of past criminal record of the accused Achal Sahni, alias Achal Sahni, preventive detention under PIT and DPS Act 1988 has been also imposed on the accused Achal Sahni. Then Lordship, please to see subparagraph D, criminal history. In NDPS case number 7/21 is under trial. There is involvement of 1586 of kg of ganja. Then 2. NDPS case number 19/2020 ganja 345 kgs. Then C 23/21 207 kg of ganja. He was arrested, so he was shown arrest in this case. Then another 4, item number 4, 20/21. Accused Achal Sahni was shown arrest. And all the cases are under trial. Here's the past history.
All these cases are pending here in Guwahati.
In 3 cases, he was shown arrest also.
In 3 cases, Lordship, I am shown arrest in this case, Lordship. May I, on the basis of the statement, Lordship, my name comes out in the case, Lordship. The other thing is that, Lordship, in this present case, Lordship, nothing should be recovered from myself, my side also there, Lordship.
No,
because-
okay, first let him complete. Yes.
Lordship, page 106, paragraph 8. His involvement in the case is narrated here. Evidence found during investigation of the instant case against Akhil Sani, alias Akhil Sahani. On Akhil Sani is the accomplice of main supplier Pradeep and receiver Amit Kumar Mahato, receiver Tuntu Mahato, receiver Papu Sani. Vehicle provided Pradeep Sharma and vehicle owner Gurdeep Singh. Because Akhil Sani has disclosed the name of mobile number on other so. Then Lordship, paragraph 5, CF of the mobile number so, accused Akhil Sani was analyzed and it is found that it be registered in his own name. An analysis of CDR, it is found that the accused son, Akhil Sani was contact from 25/9/2021 to 23/2021 with suspect Papu Sani, alias Papu Sani, 227 times, with Papu Sani, Papu Singh 160 times, with Akshay Kumar 7 times, and 28 times, with Gurveer Singh 92 times, with Kuldeep Sharma from 25/9/21 with 15/11/21 257 times. Then para 6 from the analysis of PDR mobile of accused Akhil Sani, it is found that accused Akhil Sani was in contact with suspect Pradeep from 25/9/21 to 23/10/21 72 times. Then involved in trafficking of ganja seized NCBI crime number 21, 426 kg, which is not more than commercial quantity. In paragraph 9, Akhil Sani is habitual offender of NDPS Act and involved in many cases of NCB. He is also involved in NCB crime, which I will be given details also. In this case, Lordship, 29 packets consisting of 426 kg of ganja was seized. Paragraph 9, that during the investigation, it is previously established that accused persons, Akhil Sani, and other accused persons are in the instant case were consciously involved in commissioning of trafficking of ganja and presumption under section 35 and 54 of NDPS Act. As to culpable mental state of the accused can be drawn. From the facts of the circumstance stated above, it may be established that the accused person, Akhil Sani, was arrested for his conscious involvement in his illegal trafficking of ganja, which is much more than constitutional. This is in violation of provision of section 8C of NDPS Act and is liable to punish under Constitution. Lordship, for the same judgment. Paragraph Paragraph 8 to 9 of this judgment, Lordship. Although facts are slightly different regarding law laid down by the Honorable Supreme Court. Paragraph 5, 6, 7, and 8.
This is judgment passed by your lordship in another case. Your lordship has taken ground that a delay cannot be a ground for granting bail in case of NDPS. Lordship, furthermore, the bail application of co-accused has been rejected by this honorable court on 10/9/2024.
Which one?
Co-accused, the bail application of co-accused Gurvinder Singh was rejected by this honorable court on 10/9/2024. We'll provide a copy of the lordship.
Okay. Yes, Mr. Dubey.
Lordship, I'm not going to talk about the Lordship, whatever the cases should be pending against me or not, Lordship. I'm presently in this matter, Lordship.
No,
Well-
but Mr. Dubey, you see, the contraband substance recovered from your possession is of commercial quantity.
No, Lordship, nothing recovered from me, Lordship. See, I have
Maybe.
nothing recovered from my possession, Lordship.
Maybe, but involved in this case.
Through CDR and the.
No. The contraband substance involved in this case is of commercial quantity.
Yes.
Therefore, in view of decision of Honorable Supreme Court in the case of Nawaz Khan, you were to satisfy the requirement of Section 37 of the NDPS Act, that you are not guilty of the offense and that you will not commit any offense while on bail. So how do you satisfy these two requirements?
Lordship, first thing that, Lordship, if the courts, honorable courts allow me to go on bail, Lordship, I will give a government person there, Lordship. I'm only
No,
asking.
no, 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 no. That you are not guilty of the offense.
Because Lordship, at that time I am to be the, in this case, Lordship, at that times I was behind the
So
bar.
it appears from his objection petition
Yes, Lord.
that as many as 4 cases are pending against you.
Yes.
It seems that you are habitual offender.
But in all 3 cases, Lordship, shown arrest, Lordship.
Maybe,
Shown arrest, Lordship. Only
maybe.
on the basis of the statement of the co-accused, Lordship.
So unless you satisfy the requirement of Section 37, how the court can grant you bail? Tell me.
The condition should be imposed on me, Lordship.
Condition is there. Condition is not the.
Any condition, Lordship. Because, Lordship, there is a original Article 14 also there, Lordship, a long time, 1084 days, Lordship. And
No, Article 14, how Article 14 will help you?
Lordship, my submission that.
There is a
Lordship,
justified ground for curtailing your liberty. Anyway, we'll pass the order.
Much.
Lordship, my lord, this is not in report. Lordship may kindly be pleased.
When you have filed it?
Lordship, it has been more than 2 weeks. It has been filed.
How will you call it?
Dismissal. Timing item 16.
Taken in session that they are willing to consider the case
Pardon?
for admission.
They will consider.
Consider.
When?
Within before the 1st of November, as per the.
No. Thereafter, you cannot take the plea that time is over and we cannot admit him.
My lord will make an direction.
Observation.
That before 1st of November, as per the policy, the admissions in July.
No. We will keep the matter pending.
Yes, my lord.
You comply with the order.
My lord. Well, they will admit the petitioner, not they will consider, my lord. They will admit.
Admit.
As it is submitted, they will consider admission. No, my lord. What I said, they have to admit, my lord, as it was ordered, my lord. But I am saying, my lord, I think petitioner should at least understand that, consider means they will, I have talked to the officials personally, they will take the admission. If my lord wants to keep it pending, my lord, can keep it.
Okay, we will grant you 1 week time. You admit?
No. My lord, may I just, my lord, subject to correction, my lord. My lord,
the petitioner will appear before RIMC authority on Friday, if possible, because he has to fly from Guwahati. He will appear before RIMC authority on Friday for admission, and let the matter be again listed before this honorable court on Monday, my lord, if possible, my lord.
Yes.
That is upon the petitioner, he can go even to day after.
No, you inform him the exact date and time when he will appear before the authority.
We'll go for admission
Uh,
with all documents and all.
So any date they want, मतलब before 1st of November, any date they can go.
Because as per the
no,
policy,
they
that
can
will-
go tomorrow also.
Let them go tomorrow. Once we have said we are going to consider.
It's a vague, my lord. I feel so, my lord. It will be
Hmm.
vague, my lord.
Hmm.
Let there be a date, because we have to fly also 3%.
Hmm.
So we will be, if there is a direction from or order reflected, that we will appear on Friday as they have agreed upon.
Hmm.
And on that they will be admitted, and the matter will be again listed before the court on Monday. Monday will be
28th.
yes, 28. Because the time is very short, only 10 days we have. Again, if they are to call us, they will issue some call letter, then it may delay them. And they will then say that 1st of November is over.
No,
That can
Mr.
do it
Gupta,
one-
you obtain a specific instruction on which date he will appear before them for admission.
Well,
We'll take the matter as a last item today. Because the time is very short.
And my lord, what I think, my lord, that date LC instruction gets, that will be part of the record, my lord. And we'll get a copy of the order also, so that they.
Yes. Will reflect it in the order
Yes,
Oh, my lord can take it tomorrow as a first item.
I will,
tomorrow.
yes.
Oh, why not today at 4 p.m. or 4:30?
I'll take.
Hmm. 4 p.m. then, at 4 p.m.
No.
4 p.m.
Hmm.
Oblige.
So items, at number 22 for orders.
Lordship, by order date in 19/7/24, your lordship allowed us to take step upon respondent number through paper publication, lordship. We failed to take step pursuant to that order, lordship. We could not contact with the client, lordship. So I am praying for further 4 weeks time, lordship.
Miss, your good name?
F Inters.
FMTS, Learned Counsel for the Appellant, submits that she could not take step upon the respondents pursuant to order of this court dated 19/7/2024 and price for granting her 4 weeks time. 4 weeks time period is accordingly allowed, recess unless the matter after 4 weeks.
Okay.
23.
Lordship, this case is, earlier advocate was engaged by this appellant company. He was left, and I have engaged later on. So I got this some document also from my friend. So my lord, this is not yet appeal is not yet admitted. Delay is gone on. So today maybe admit the appeal, and I'll pay, my lord. It is a 43 lakhs amount. I paid 20 lakhs today because we have challenged the quantum as well as others. So 20 lakhs because there is a 2 insurance company. One is United. I am here for the United. Another is New India. So my lord, in the meantime we paid 20,000. Stay may be granted. This appear for the 1 and 2, and 5 also appear. 5 is a New India.
You are for
Appellant.
appellant.
Yes, ma'am.
You will pay how much amount?
20 lakhs. Ma'am.
20 lakhs.
Within 4 weeks.
Within
4 weeks.
why 4 weeks?
4 weeks, my lord. In the registry.
No, 4 weeks.
4 weeks, madam, not 4 months. 4 weeks.
No.
Within a
Within
month.
2 weeks.
2 weeks, otherwise not difficulty because
Why?
because some other cases are, that is why I'm not going to say, madam. 4 weeks, within the 2 weeks,
No, no, no,
maximum
no.
to max to 4 weeks.
No.
Otherwise, my lord, serious
This
wait.
appeal was filed in the year 2018.
Yes, my lord. Because the appeal was filed in the year 2018, there is a delay. During that time, delay was condoned. And subsequently, it is left by the appeal and advocate.
No, within 2 weeks, you deposit the amount before the receipt.
And if it is 3 weeks, it is, otherwise, my lord, it is some difficulty. Another, I have to pass an order.
No.
It is lordship.
Heard Mr. T. Kolita, learned counsel for the
My lord, not
appellant.
No, RC Pal. I am RC Pal.
You are RC Pal?
Yes.
Okay.
Sorry.
RC Pal, learned counsel for the appellant. And Mr.
A.K. Misra for respondent number 1 and 2.
A.K. Mesa, learned counsel for the respondent
Six
number
times
1 and 2.
Your Lordship, I would like to something for this that is case is fixed for order since 2028. And the awarded amount is 44 lakhs. So minimum half of the amount of awarded, 50% of the awarded amount may be deposited, order to be deposited by the appellant.
Yeah,
So
there
20
is a
lakhs,
matter.
so
Why I am saying that
50% amount is 22 lakhs.
I know, my lord, 43 lakhs or
99 lakhs.
so, my
99
lord, that is a two vehicle. This is the first challenge. Second is the minor quantum. Because quantum is disputed, accepted in not erroneous.
No. You are directed to pay the entire amount.
No, 20 lakhs. Out of 43 or awarded amount. We'll pay 20 lakhs at this stage.
No.
Your Lordship, the awarded directed
Otherwise,
to the
if I
only
pay my
United
entire
India
amount,
Insurance
what is the
Company.
my appeal?
Let me submit. Your Lordship, awarded against the United India Insurance Company alone, not for other insurance companies.
Maybe it is, that is why I challenge it. Otherwise,
No, you pay the 50% amount.
22 lakhs might be.
No. This appeal under section 173 of the MB Act is directed against the judgment and award dated 24/1/2018 passed by the Additional District Judge Dibrugarh in MSC case number 24 of 2011. It is to be noted here that by the impugned judgment and award dated so and so, the learned member Motor Accident Claim Tribunal Dibrugarh in MSC case number 24 of 2011 directed the appellant to pay a sum of rupees 43,99,200 rupees along with interest at the rate of rupees 6% per annum from the date of filing the claim petition, that is 18/4/2011 till the date of realization. Mr. Pal, learned counsel for the appellant, submits that the appeal has not yet been admitted, though notice was issued to the respondents by order dated 5/9/2022, and therefore Mr. Pal contended to admit the appeal and to call for the record. Having heard the submission of learned advocates of both sides, I have carefully gone to the memo of appeal and the grounds mentioned therein, and also the impugned judgment and award dated 24/1/2018. Admit, let notice be issued to the respondents number 3, 4, and 5.
Already notice has been served, Your Lordship.
Yes, my lord.
So for the
Well,
office
it's
notice,
You are for respondent number
1 and 2.
1 and
He is
2.
of the respondent number 6.
Whether notice is not required to be issued to them.
My lord, 6 is already appeared, August company. This is appeared, shown to be, his name is shown in the call list. My lord, respondent number 6. Counsel.
So 3 has expired.
Yes.
And 4?
4 is, my lord, not appeared. Not
No, whether notice was served upon him or not.
it was served, my lord,
When?
earlier.
Is there any order to that effect?
In the my lord, delay application. Because today is the first time he is admitting this appeal. Today is the first time this honorable court is issuing notice. That is why, my lord, delay, in the delay application, we have already noticed to each of the respondents.
Maybe, but here in this appeal also you have to
My
issue
lord, I
notice.
think the 5 is not necessary, struck out. Because we have challenged the quantum and the
কি করলো? Let notice be issued to the
respondent number 6 is
respondent
important.
number 3, 4, and 5. 5 and 6.
The 6 is, my lord, already appeared. New injunction. Counsel, it is shown in the call list.
Later on, Mr. Paul, learned counsel for the appellant, submits that respondent number 3 has already expired, and respondent number 4
Is the owner of the Tata Somu, not necessary, my lord.
owner of the
Tata Somu.
owner of the vehicle, and 5
is the insurance company of that vehicle. They have already contested the case in the lower court.
and 6
Five is the owner of the truck. 5 is the owner. 4 is the owner of the truck. That is the offending truck. What the court says. Offending truck is the my truck. Is the appellant truck. So 3 and 4, 3 is the, my lord, driver is expired. Owner is already 4 is the owner of the truck of the appellant insurance company. Then 5 is the owner of the Tata Somu. So I think it is 4 and 5 is not necessary. 6 already appear on behalf of them, on behalf of 5.
No, 6 is Govt of Assam.
Yeah.
6 is New India.
7 is Govt of Assam as per memo of appeal, my lord. Not a Govt of Assam is not necessary. I do not know why it's with the party. Because
4 is the driver. 4 is the owner of the truck. And 5 is the owner of the Tata Somo.
And 7 is not necessary.
6 is the New India Assurance.
6 is already appeared.
And 6 has already entered appearance.
Yes, shown in the call list.
And respondent number 7
not necessary.
is not a necessary party, and as such, the learned counsel for the appellant submits that the name of respondent number 4, 5, and 7 may be struck off from the array of this appeal. Having considered the submission of Mr. Paul, learned counsel for the appellant, the name of respondent number 4 and 5 and 7 be struck up from the array of this appeal at the cost and risk of the learned counsel for the appellant. Dismissal call for the record from the learned member MSCT. Dibrugarh. List the matter after 4 weeks. There is one IA.
Yes, IA is there, madam. IA is my state petition for 2287.
Subject to payment of rupees
50%.
Subject to payment of 50% of the awarded amount before the registry of this court.
3 weeks time.
Within 3 weeks, within a
Before the
period of
registry.
3 weeks from today.
Before the registry. Before the registry.
Before the rest.
Much of that.
With the direction to release the same in favor of the claimant, you all.
Yes.
And on depositing the said amount, the same shall be released in favor of the respondent number 1 and 2.
Item 24.
One thing. The respondent one is the wife of the deceased. 2 is maybe minor segregate
for fixing in the court some amount also. Otherwise, 22 lakhs will be withdrawn.
From the final amount.
There is also order also there in the lower court also. There is a fix in some amount also.
Now, order fixed against the minor who was at the time of minor, but now he become major, your lordship. At the time of filing of this case, he was minor.
No, at the time of final settlement,
Yes, your lordship.
that can be looked into,
Your lordship.
not now.
24.
The 24 my lord already service is complete and my lord is appeared. NCR already received. It's for hearing.
My lord, the urgency from our side, the claimant's health condition is not so good, my lord. So some shortage my lord may be given.
The first week of my December.
Both the parties are duly represented by their engaged counsel.
NCR
It is submitted at the bar that the service is completed. And the share has also been received and the matter is ready for hearing. Accordingly, it is provided that res is a list nota for hearing on
1911.
Not 1911, first week of December. Otherwise, some difficult one. First week of December.
Take a date from me.
Yes, first week of
25.
Also, in this case, appellant counsel has withdrawn the Vakalatnama and no new counsel has filed a Vakalatnama yet. And your lordship last order dated 1/10/24 is given the last opportunity, your lordship. These are connected matters, your lordship. 25, 26, 25. Prior to that also, lordship, on other date also, they have not appeared, lordship.
None appears for the appellant on call. However, Mr.
He does.
Learned counsel for the respondents present. Office note dated 5/10/2024 indicates that the appellant have not yet engaged a new counsel to represent their matter, though the registry has informed them through a notice dated 18/6/2024 about the withdrawal of their earlier engaged counsel, Mr. Zay A. Soikia. But no reply has been received from their end. In view of above and also in view of the submission of learned counsel for the respondent, and also taking note of the order dated 1/10/2024, 25/9/2024, this court find no just ground to adjourn the case to another date, and accordingly the same instance dismissed.
This is one, I'm for the respondent number 1, your lordship.
Okay. Respondent number 1. And your good name? Oh, respondent number 2. Okay.
26, 27.
Same.
Same, your lordship.
27 is also same.
Yes, your lordship.
Take matter. Okay.
28 and 29.
Last petition, they have served a copy of the judgment, the writ appeal 33/2010 ballot. According to them, that this is the covered measure which, along with rate appeal number 3, but that has been pending before the Supreme Court. That SLP number is 8024 of 2018, my lord. That has been challenged before the Supreme Court, my lord. And SLP number is 8024, and next date is, my lord, 23rd February 2024.
25
Sorry,
February.
no, not the 18/11/2024.
So we'll list this matter after this
Yes, sir,
then.
18/11.
Lordship, I have a objection in this matter. Lordship, the railways have been stating the same thing since last 3 to 4 years. Lordship, upon the same issue raised by the Honorable Chief Justice of the Guwahati High Court, Honorable Chief Justice had given a specific direction that the matter should be, that there is no specific stay given on the particular question of law by the Supreme Court. Thus, the matter should be listed and no more adjournment should be granted on account that SLP is pending before the Supreme Court. And eventually, the same has been recorded that there is no specific mentioning this judgment, 333 SLP is pending. The SLP number is mentioned and it has been stated that there is no specific stay and court should not grant adjournment merely because an SLP is pending before the Supreme Court. Upon the specific direction made by the Honorable Chief Justice.
In which matter that direction was issued?
Lordship, in the case of MFA 24, 2016, in the case of Union of India versus Jokes Attack Operation Limited. Lordship may kindly look upon second last paragraph. Second last paragraph of the order.
Who passed the order?
Lordship, the order has been passed by Honorable Justice K.R. Surana. However,
But you have submitted that as Chief Justice passed the
yes,
order.
yes, Lordship, upon Lordship may kindly look upon last third paragraph of this judgment.
No, my question is who passed the order?
Lordship, the order has been passed by Honorable Justice K.R. Surana.
Then
Upon the
why you have
direction,
taken the name of Chief Justice?
upon the direction made by the Honorable Chief Justice, Lordship, in another matter, a private respondent has approached the Honorable Chief Justice that there is no stay given by the Honorable Apex Court.
Heard Ms. K. Gayon, learned counsel for the appellant,
Lordship,
and also heard Mr.
D. Rathi.
learned counsel for the appellant.
Lordship,
No, respondent. Ms. Gayon submits that when SLP is pending, being SLP number,
8024/2018.
and the same has been listed on 18/11/2024. And as such, a request is made that this matter may be listed after that date, after 18/11/2024. The learned counsel for the respondent, however, raised objection in adjourning the matter. Having considered the submission of learned counsel for this court is inclined to adjourn the matter to be listed
my lord,
after.
my lord, I have a submission that kindly
Sorry,
this order
don't disturb at the time of dictation.
Lordship may kindly record the order in the judgment. Because specific
No, it is not
instruction-
relevant, therefore we will not
Honorable
record.
Chief Justice has given, Lordship
Sorry.
may kindly look upon a specific instruction has been received. Justice K.R. Surana has observed that Honorable Chief Justice has given a specific direction.
You go to that court then.
30, Lordship, my humble submission is
Sorry.
my judgment may be recorded in the order. Judgment
Sorry.
which I'm stating may be recorded in the order. I have no problem.
Sorry.
Lordship. Lordship may adjourn the order.
Sorry.
Adjourn the matter for the today. Lordship may at least record the judgment which I am placing before the Honorable Court.
Sorry.
Made with the loss. My lord, in this IA, there are 3 respondents, my lord. The respondent number 3 has already appeared, my learned friend.
I'm for the respondent number 3, Lordship.
As per the office note, my lord, on respondent number, service and respondent number 1 and 2 have already been cleared. If office note is there, my lord, dated 2/4/2024, my lord. Yes. It is a delay matter, my lord. The delay is 24 days, 28 days. So this delay kindly be considered when my filing the appeal. And I have explained the reasons of my delay in paragraph 5 of my petition, madam. Your lordship may kindly bear with the same. He is a government employee, he failed to appear in time. Paragraph 4 of my IMI. So after the delay, respondent matter may come up for admission.
Yes, any objection?
No, no.
No objection.
No objection.
Heard Mr. M. H. Raza
Rajbur,
Ras Borboya and also learned counsel for the applicant and Mr.
Eka Koti lordship.
A. Kakote, learned counsel for the respondent number.
Number 3 lordship.
Respondent number 3. Office note dated 2/9/2024 indicates that service upon respondent number 1 and 2 deemed to have been completed by the laws in accord by order dated 5/4/2024. But no one entered, no, but the respondent number 1 and 2 remain unrepresented today. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant Rahimuddin Laskar for condonation of delay of 27 days in filing appeal against the judgment and award dated 21/8/2023 passed by the learned member MSCT Kasar Silsor in MSC case number 657 of 2019. Mr. Rajbar Hoya, learned counsel for the appellant, submits that. What is the ground for
My lord,
filing the?
he is in government employee, my lord, is a teacher. I have mentioned in paragraph 4, my lord. He was not in a position to avail leave because of the administrative restrictness. Ultimately, having a job in the DPI office, he made an attempt to meet the council. He came to Guwahati with an official work in DPI office. In the evening hours, he came to meet me and handed over the file.
Mr. Rajbar Hoya, learned counsel for the applicant, submits that the applicant has been serving as a teacher of Swaden Bazar High School, situated at Dokhin Mohanpur, Part 10, under Sonai Police Station. And because of his preoccupation in his official work, he could not manage to meet his lawyer at Guwahati, and therefore he could not file the appeal in time, and that the delay is not intentional, rather it is circumstantial, and therefore it is contended to allow this application by condoning the delay of 27 days in preferring the connected appeal. The learned counsel for the respondent number 3 submits that he has no objection in the event of condoning the aforementioned delay. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also peruse the consider petition and the documents placed on record. It appears that in paragraph number 3 and 4 of the petition, the applicant has mentioned the grounds for failing to prefer the appeal within the stipulated period of limitation. And it also appears that the delay is not intentional, rather it is circumstantial. And the same appears to be explained sufficiently, and therefore this court is inclined to allow this petition. And the delay of 27 filing the connected appeal stands allowed. No, stands condemned. In view of order passed in IA number 19 of 2024, now the registry will proceed to register the appeal and list the same before the court.
31.
In
Appeal
terms of
appeal may
evidence,
kindly be registered in, appeal may kindly be registered by the office.
we have already directed.
Much obliged.
Mm.
31.
Lordship, this is an FAO. In last date, I have been directed to bring on record the order dated 25/3/2004, passed by the civil judge Sunit Court. But because of these holidays, I could not have been delivered this order. That's why kindly adjourn the matter for 29th. Lordship.
What is your name?
Ghanshyam Das Dhiman, Lordship.
Heard Mr. Ghanshyam Das Dhiman, learned appellant in person. And Miss A. Gayon, learned counsel for the respondent. The appellant in person submits that though white order dated 30th/9/2024, he was directed by this court to place on record the order dated 25/3/2004, passed in title suit within bracket ARB number 03 of 1999 by filing an additional affidavit, yet on account of holidays he could not obtain the order, and therefore contended to grant him some time, more time. Here is accordingly allowed. Justice allays the matter on
29th, Lordship.
29.
29th. Obliged, Lordship.
Item 32.
Well, the notice was issued and I have taken steps, but which says
next time you can this before another bench. Yes.
notice was issued, my lord, and I have taken a extension on the private respondent, then government also, my lord. But in the office, office note, notice in the service is not completed. At some time, you know.
You want to take fresh step?
We have taken the same limit, so some time or people worship so.
Heard Mr. A. Rosset, learned counsel for the petitioner, and Madam Burman, learned counsel for the respondent number
3 and 4.
respondent number 3 and 4. Office note dated 14/10/2024 indicates that service report upon respondent number 1, 2, 5, and 6 are awaited. Places shall list the matter after 2 weeks, awaiting service report upon respondent number 1, 2, 5, and 6.
My lord, we filed a review application against an order passed by your lordship on 19/8/2024. Lord, there is a delay of 13 days in filing that. My lord, nonetheless, my lord, I would like to argue the review petition to some extent in order to persuade your lordship to get an status quo order. And what happened? Your lordship passed an ex parte order on that day. And the council, my lord, tried to persuade your lordships by giving some, my lord, the wrong statement. As a result, my lord, your lordship was persuaded to pass that order. My lord, if I take your lordships to the impugn order, which was impugned in that particular date, was 5/8/2024. That order was passed by the learned civil judge, senior division. My lord, saying that, my lord, I would like to take your lordship to that order first. If your lordship take the review application, my lord. Review
Now, this
application.
IA is for what purpose?
IA is, my lord, there is a delay for filing this review petition. There is a delay for 13 days, my lord.
13 days.
13 days, 1-3.
So let notice go at this.
My lord, usually, my lord, your lordship used to pass that sort of order. But here, what happens, my lord, by virtue of the order passed by your lordships, the order, restraining order, which was passed by the learned civil judge, that was vacated, and the next date was fixed for hearing both the sides. In the meantime, my lord, we have the apprehension, the conduct of the other side in such a nature, your lordship will find there is a decree by the civil judge junior division saying that, my lord, the revenue authority can measure the land, which is my land, and they did not implead me as a party. And we filed an application to implead as a party, that was rejected. Against that, we filed an appeal. Appellate court has stayed that particular decree of the junior division. Nonetheless, my lord, in the subsequent day, my lord, they went there with the help of the police, and my lord, one station gate is there that was broken and entered into the land. Now, since there is no restraining order, what they might do, they can enter into my land, take up the position, and there will be, my lord, the multiplicity of litigation will come up. Now, in that view of the matter, my lord, nonetheless, there is a delay of 13 days. If your lordship protect us, the status quo as on today, that may be maintained, my lord. We are not asking for status quo ante, but we are asking for, my lord, we are trying to persuade your lordship that status quo as on today, my lord. They're not going to be prejudiced by any means because we are in possession of the land. To that extent, my lord, if your lordship protect us, my lord, for the interest of justice, my lord, that possibly we can canvass before your lordship.
The problem is whether a review petition lie against this order.
Beg your pardon.
Whether review petition lie against this order.
My lord, yes, because the order passed, whatever the passed by the honorable court, my lord, the review lies against that. So there is no, my lord, true opinion on that. Your lordship may scrutinize that point also, but for the time being, my lord, your lordship may issue notice and the status quo in regard to the land in question, that may be maintained.
But the problem is that without condoning the delay,
my lord,
can we pass such kind of order?
My lord, that your lordship is rightly, your lordship put that question. But my lord, in a given case where there is imminent danger of my lord entering into my land, your lordship has seen, I can take your lordship to those orders. My lord, decree was passed. That decree was stayed by the appellate court. Now, when the learned civil judge junior division, after passing that particular decree, his office is functus officio. He cannot pass further order. What he did after 15 days, he passed another order that the police was asked to go there and break open the CIC fencing, in spite of the stay order given by the appellate court. Now that was the situation now. My lord, they can enter into my land, which I am in possession. And your lordship kindly see the fallacy of all this case. Now, they are claiming my land. They did not include me as a party. The defendant have been included circle officer and one lot mandal, because they want measurement of that land, and they did not include me as a party. Now I filed an application, kindly include me as a party because it is my land. That application was rejected. Then I filed an appeal. Appellate order that decree was stayed. Then further, apart from filing the appeal, I filed another suit. In that suit, my lord, I filed an application under 39(1) and 2, read with 151. Then that this injunction application show cause was given to him. The date was fixed on 22/8/2024. In the meantime, my lord, the police has gone there, they broken the CIC fencing. And in that view of the matter, I had to file another application under section 151. And the learned judge, what happened, they have given a picture to your lordship that without hearing them, the order was passed, but it is not. When they filed this application on 151, it was fixed on 2/8. Then they were asked to give a copy to the other side. Copy was given, and they were requested to present on 5/8/2024. In spite of the order passed by the court, they did not appear. Now, just to protect us, the learned judges passed that order that they should be restrained to enter into the land. Now, they have come up against that order with your lordships. And on the day one, when it came up on motion, my lord, they given a picture to your lordship that it was passed behind their back. That position was not correct at all, because the impugn order, the order which was passed on 5/8, that has reflected that they are given all chance, they are given the copy of the petition, and they are asked to be there on 5/8, although the application was came on 2/8. Now, it was not an order which was passed behind their back. They avoided the court. They did not come intentionally.
We'll fix a short date. You take step upon respondents. After condoning the delay, we will consider your pair.
That your lordship.
But without condoning the delay.
That I understand, my lord, that predicament is there. I can't insist your lordship also. But in sometimes, my lord, the appeals court also say, if there is a very genuine situation, in some cases.
Do you have any citation on that point?
Particular citation, my lord, my learned had that, but he could not locate. But one judgment of this honorable court by Honorable Justice
Jain Sharma.
Jain Sharma, your lordships well aware, possibly. The lordship's judgment was also there. Even in the, without condoning the delay, that order can be passed. My lord, I leave up to your lordships. If your lordships feel that.
But the problem is that the judgment, not judgment, it is an order of this court passed by Justice Jain Sharma.
Yes.
Like small order.
Yes.
Small order. No law has been discussed there.
Of course, your lordship
So
is right.
reading that as a precedent, it is difficult.
My lord, as your lordship is saying.
So we will fix a very short date. You try to serve notice. We will permit you to serve notice by Dhasti mode also.
Right.
Heard Mr. S. Dutta, learned senior counsel assisted by Mr. Biswas, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 13 days in preferring first appeal. First appeal or review petition?
No, it's a, my lord, review petition.
So what is this then?
My lord, this is a IA application for.
In IA, you have mentioned it as first appeal.
No, interlocutory application number P153, then review application number so and so, in CRP number so and so.
No, in the This in the matter of last line, 13 days
Please.
in preparing. Page number 1.
Oh. My lord, that's wrong. Yes, your lordship is correct. That should have been review application. My lord. Because nowadays, your lordship can see the copy paste idea has given all this problem. Because we give to our typist to type it, they type it from, they just copy paste. So, my lord, sometimes they commit this sort of mistake. It should have been a review petition. They have typed it as the first appeal. The culture of copy paste only.
But you have to amend this application, no?
Melody, in fact, if your lordship see on the top, interlocutory application number so and so, review application number so and so. Now, that is the main thing, my lord.
There is one notification also. We cannot allow to correct it by hand now.
Yes, yes. Now it has come. That's true.
What to do?
Your lordship can ignore it because essentially it's a case of review application.
No, that's all right, but without correcting this.
Now, the prayer is, my lord, it's a review application. If your lordship look at page 11, my lord. The prayer portion, it is therefore prayed that your lordships may be graciously be pleased under the facts and circumstances of the case have been narrated herein, this application to condone the delay of 13 days, which have occurred in preferring review application for taking
13 days in preparing review petition.
Yes.
Let notice be issued to the respondents, returnable in 4 weeks. No, returnable 1 week.
My lord, yes.
1 week, returnable in 1 week. To be taken by registered post with ADA and also by usual process. Dusty service is also permitted. List the matter on COVID.
On 28.
28.
Maybe 10 days, my lord.
10 days.
Dusty will take
10, then on 4th November.
4th of November.
Much obliged.
35.
Correction can you
Make is a lot. Testamentary appeal, madam. IA for delay of condonation of delay of 48 days, madam.
Heard Mr. Das, learned counsel for the applicant. This application under interlocutory application under Section 5 of the Limitation Act is preferred for condonation of delay of 48 days in preferring connected testamentary appeal. Let notice be issued to the respondents, returnable in 4 weeks. This to be taken by registered post with ADA and also by usual process within our today. List the matter after 4 weeks.
36.
May please, those could also delay petition first time notice mechanism. 81 days.
Heard Mr. Agarwal, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred for condonation of delay of 81 days in preferring connected MSC appeal against the judgment and award dated 16/2/2024 passed by the learned member. Motor Accident Claim Tribunal number 2, Kamrup M. Guwahati in MSC case number 2073 of 2021. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. List the matter after 4 weeks.
37.
Also same note. Delay of condonation petition first time notice. 37. 37 is also same note.
Same, okay, same.
38.
Limitation is barred by 160.
Pardon?
My lord, limitation is barred by 165 days, my lord. It is for the first time, my lord. Let them notice me.
Third, Miss
Else,
L. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred for condemnation of delay of 165 days in preferring appeal against the judgment and award dated 19/2/2024 passed by the learned commissioner employees compensation. In WC case number 172 of 2022. That notice be issued to the respondents, returnable in 4 weeks, is to be taken by registered court with ADA and also by usual process. List the matter after 4 weeks.
oh, bless me.
16. I informed the other side, maybe 1 minute, I have informed already. So item number 7 to 37, let's see the number of days will be different.
Okay, we'll take care. So you had discussed the matter with them?
Yes, my lord. We have discussed. They are willing to consider, my lord. My lord, regarding the time, they are saying, my lord, that the direction be issued that, my lord, within a week, the admission should be completed. My lord, if that direction is issued, my lord, they will do the needful. Specific date, my lord, they are not giving because there are certain other formalities also. It's not that, my lord, immediately they will go and admission will be done. Whatever process is there, my lord, within the outer limit of 4 weeks and before 1st of November, it should be completed so that, my lord, the admissions are prior to 1st of November, my lord, that I have given them the.
No, Mr. Gupta, you say they have to undertake their travel from here to
Yes.
Dehradun.
Yes, my lord.
So some certainty is required because they have to go there, they have to stay there.
Yes. My lord will fix the, but since, my lord, as per the notification, my lord, before 1st of November, the admission should be completed. In case.
So what is the document you have on the other day plus before the court?
Those were part of the record, and I will again. Two documents I have given in the last week. This is regarding, my lord, conduct of entrance exam for the admission to RAMC. My lord, will take page 7. Page 7, my lord, which is a part of clause number 11, and, my lord, the relevant clause is clause F. Page 7, F. My lord, this deals with a situation, my lord, where the RIMC has to maintain additional strength, my lord, in case of withdrawal and resignations. And, my lord, it reads as follows, my lord, that RIMC will maintain an additional strength of 2% to cater for withdrawal / resignation of cadets at different times of the term. However, in spite of additional strength, if RIMC needs to admit cadets in between the term, then the cutoff date for Jan term will be 1st May, and for July term will be 1st of November. Now, since the petitioner belongs to July term, 1st of November would be the date, cutoff date for admission in a situation where there is a withdrawal or resignation of cadets during the under course.
Hmm.
My lord, will give them direct to 1 week's time, Lord. My undertaking may be recorded since I have obtained the instruction, my lord, that can be brought on record.
Hmm. Heard Mr.
T.R. Sharma.
T.R. Sharma, learned counsel for the petitioner, and also heard Mr. Gupta,
My lord.
learned counsel for the respondent. Pursuant to order of this court dated 3/10/2024, Mr. Gupta, learned counsel for the respondent, had obtained necessary instruction and apprised this court that the respondent authority will consider the pair of the petitioner, and that in view of the SOP, which is placed on record before this court on 3/10/2024, the time limit for admission in Regional Institute of
No, my lord, this is Rashtriya Indian
in the Rashtriya Indian Military
College.
College for the
July 2024 session.
July
2024 session.
July 2024 session. 2024 session is up to 1st of November 2024, and before that the authority will admit the petitioner in the aforesaid college, as some formalities are required to be observed before the admission. In view of the submission of Mr. Gupta, learned counsel for the respondent, it is provided that the authorities shall complete the entire formality within 1 week,
In 1 week.
within a period of 1 week from today, and admit the petitioner in the aforesaid course. What was the name of the course?
This is admission in class 8. Regular course.
Admission in class 8.
Class 8.
Class 8. And rest shall list the matter on after 1 week.
On 30 October.
30th October.
30th October.
And on that day, Mr. Gupta, learned counsel for the respondent, apprised this court about the status of the same. Any further direction required?
My lord, I have taken instruction from my client also. They say they can be, they can fly to Dehradun by Wednesday. They will be there. They will report RIMC on Wednesday.
Hmm.
And then the admission procedure, whatever the formalities is there, my lord, we are not aware of. That may take some time.
Hmm.
It will be done then within a week. And that may be given, then we'll report RIMC authorities on Wednesday.
Okay. In view of the submission of Mr. Gupta, the petitioner, no, it is provided that the petitioner shall report before the authority on
Wednesday. This Wednesday, today is 21st, then it will
23rd.
23rd.
on 23rd. On
October.
23rd with relevant particulars.
Yes, the copy of the order may be
A copy of this order be furnished to Mr. Gupta during the course of the day.
Acknowledgement.